Recording in progress.
Good morning, members of the Portfolio Committee. Good morning, officials from both SACE and ELRC. We're just waiting for Chairperson to log in. We should start in the next 2 minutes. Thank you.
Good morning, honorable members. Very warm welcome to our meeting this morning. Apologies, I was just trying to get a hang of the network this side of Acacia Village, but I guess it's fine. I hope I'm audible, Mr. Brown.
Yes, you are, Chairperson. Thank you.
Okay, perfect. Good morning, everyone. Good morning to the honorable members on the platform. Good morning to the delegation of the ELRC. Good morning to the DPE delegation. A very warm welcome to our meeting this morning, where we will be engaging on numerous issues that we had tasked both the department and SACE to really look at and come and brief us as a portfolio committee. You are very warm welcomed, and I'm going to request Mr. Brown to fly to the agenda so that we can go through the agenda. We can then go through the apologies and we get into the program of the day. Mr. Brown, let us please fly to the agenda. Thank you very much, Mr. Brown. So, honorable members, that's our agenda for today. I want us to firstly deal with the roll call and apologies. Mr. Brown, can we deal with the attendance register and the apologies before we start?
Thank you, Chairperson. Of yourself, Honourable Mailela. I have Honourable Kabanchaba present. I have Honourable Low. I have Honourable Kize, Honourable Mtsweni, Honourable Sikwambana, Honourable Komane, Honourable Ngubeni. I have apologies for Honourable Magagula. She has an appointment with her doctor. And I also, of course, have Honourable Jordan, who is currently on maternity leave. And then, Chair, the Minister office has indicated that she will join us a bit later. She's just at a cabinet meeting, and as soon as that meeting is finished, she will be with us. Thank you, Chairperson. Chairperson, are you? Chair, can you hear me? Thank you.
Oh, thank you very much, Mr. Brown. Thank you for the. Is there any member? Are there any honorable members that were not mentioned by Mr. Brown?
Yes, Chair. I
Please
am online.
indicate your presence.
Honorable Sharif, online, Chair.
Yes, Chair.
Okay.
Yes, Chair. Honorable Shkwamba.
Okay. So Honorable Sharif and Honorable Shkwambana are present in the meeting, Mr. Brown. Please let's note that. From SACE and the department and ELRC, any apologies?
Chairperson, I'll just check, but I don't have anything from my side. Thank you.
Okay, thank you very much, Mr. Brown. Now that we've dealt with the apologies and welcome, honorable members, the meeting of today, it's literally for us as the portfolio committee to receive a briefing from the ELRC on its role and function in addressing sexual misconduct and harassment within our schools. And the briefing, of course, from SACE on teacher professionalization interventions. And the first topic, and of course the second one, are very important for us to discuss today. Given the fact that they will serve, especially the first topic, will serve as a foundation for the engagements we're going to have with the inquiry that we'll be conducting next week. That has already been started by the Portfolio Committee on Women, Youth and Persons with Disabilities. The two topics and the two focus areas are very important. They're important to us as a portfolio committee because we understand professionalization of teachers and the interventions that must be put in place by SACE are really going to assist to enhance the education system and the education environment within our schools. And as well, we want to understand the role that is played by the ELRC, the council, to ensure that it addresses sexual misconduct and harassment within our schools. And this discussion is going to really give us an idea, and it is going to give us some form of a foundation as we go into the inquiry that we will be undertaking as a portfolio committee in the coming week. So the council and the two councils are welcome, and we are looking forward to engaging with yourselves. We are going to be a little bit strict on time. We did receive the presentations, so we're going to give each council at least 15 minutes to present, and then we go and discuss, because we do have outstanding minutes and outstanding 2 reports that we must adopt as a committee as well in this meeting. So we're going to commence with the ELRC. The delegation from the ELRC, welcome. You're most welcome, and you can then start with your presentation. You can also introduce the entire delegation so that we can know the participants in this meeting. Over to you, ELRC.
Morning, Honorable Chair, and morning to the honorable members. I'm Cindy Folker, the General Secretary of the ELRC, and I'm accompanied by Dr. Luvuyo Bono, who's the chairperson of the council. So it's only the 2 of us who are representing the ELRC. And thanks once more to yourself and the honorable members for the opportunity to brief the committee on our role in respect of the matters. Chair, we were before the committee not long ago, but we thought that it's prudent that we remind the committee that the ELRC, unlike SACE, Umalusi, the ELRC is not a public entity of the Department of Education. We operate independent of the department, but our work supports the Department of Education. We will elaborate on that, Chairperson, as we go through the presentation, because from time to time in the interactions that we have with those who operate within the sector, this confusion always creeps in that we are an entity of the department and we are not an organ of state, nor are we a public entity. Chair, our work is informed by the Constitution of the country, Section 28(2), which places paramount on the interest of the child, on anyone who has to take decisions or who has to handle matters that involve the children. For the purposes of today, what is also critical for the committee to note is Section 17 of the Employment of Educators Act, which imposes a mandatory dismissal sanction on educators who are found guilty of sexual assault on the learners or those who would have held sexual relations with the learners. The other piece of legislation, Chair, for this purpose, and in particular the section, is your LRA, Section 188, capital A, which talks to both the employer and the employees agreeing to subject the employee to a process of an inquiry by an arbitrator, which previously was referred to as a pre-dismissal hearing. In other words, the misconduct would have been serious such that both parties agree that, as opposed to engaging into an internal disciplinary process, you subject that process to Section 188, capital letter A. The Children's Act, Chair, it's important in its entirety, but for this purpose, we're highlighting Section 120 to 123 that talks to the reporting to the Department of Social Development in cases where one would have been found guilty of violating the children in the form of sexual misconduct, and that too will elaborate later. Criminal sexual offenses and related matters as amended, that too affects our role in these processes. And finally, Chairperson, Collective Agreement number 3 of 2018 of the ELRC, which gives the ELRC the authority to deal with the disciplining of educators where allegations of sexual misconduct would have arisen. In other words, we have taken over that responsibility from the employer, but it is now dealt with in the collective agreement as provided for in section 188, capital letter A of the LRA. Chair, I need to pause here and distinguish between two issues. For this purpose, the employer is the 9 provincial departments of education. The Department of Basic Education nationally is not the employer, and accordingly, they are not involved in the disciplining of educators, whether for this or any other type of misconduct committed by the learners. And that too, Chair, we want to clarify, because we have noted sometimes from the media comments that the pressure would be directed at the Department of Basic Education at national, but the employer, it is the 9 provincial departments. This collective agreement, Chair, as I've explained, it has taken away the responsibility from the 9 provincial departments to subject these educators to an internal disciplinary hearing, but rather it is subjected to the compulsory inquiry, which is conducted by our arbitrators who are impartial, who do that process independent of both parties. And the rationale behind the parties to the ELRC having agreed to this exercise was informed by the allegations of how these processes were dealt with in 9 provinces based on who was the presiding officer. You'd find that, notwithstanding the fact that Section 17 imposes that mandatory dismissal sanction in some provinces, these educators who would have been alleged to have committed this type of misconduct would get away very easy by being issued with the final written warnings, the suspension of the salary, which went directly against the provision of the Employment of Educators Act, and it was also a direct violation of both the Children's Act and the Constitution of the country. The other concern or consideration, Chair, was how the learners would be exposed to secondary trauma, because if the department as the employer subject the teacher internally to the disciplinary hearing, the learners who are victims in the process would be required to go and testify. And then when the department dismisses that educator, the educator exercises the recourse of approaching the ELRC, alleging unfair dismissal. The ELRC's commissioner would then invite the same learners to come and relieve the trauma of that which they would have been subjected to. And the third aspect, Chair, which we talk to at a later stage, is the SACE process, which is also another layer that these learners are still required to go and testify for these educators to be found guilty by SACE. We'll reflect on that, but I think SACE will also talk into details in terms of their role in that regard. The other important aspect, Chair, was in respect of how these cases were conducted internally by the 9 provincial departments, wherein the learners will come into direct contact with the alleged perpetrators. No special venues were in place. No intermediaries were appointed to ensure that that evidence that is led by the learner is led through a third party, and that is another way of protecting the learner from coming into direct contact with the alleged perpetrator and those that are representing them. Now, how do we go about the process itself? As per the agreement, the employer investigates where there are allegations that teachers have committed this type of misconduct. The employer investigates, they formulate the charges, and then refer the matter to the ELRC. And once these allegations have come to the surface, The mandatory requirement from the employer is for the educator to be placed on immediate suspension. So when the investigation is undertaken, under no circumstances should that teacher be still in the school. We will also talk to that chair and show or illustrate how then that affects this learning and teaching in the course of budget cuts that are there, because provinces have expressed a concern that they do not have sufficient resources to appoint substitute teachers. So all these processes, they tie up together. Chair, I've already mentioned that we appoint a qualified, impartial, and an experienced arbitrator to preside over that case. I've also touched on the use of intermediaries, which are the social workers, the psychologists, and we've been relying on some of the provincial departments that have a sufficient number of social workers. We subject them to the training that is provided by the Department of Justice, because our processes run exactly the same. The children's courts deal with cases where children have to go and testify, especially on cases of sexual offense in nature. So we've been assisted by them to train the social workers, though they have some sort of training. We also recruit independently the intermediaries. As I said, we are directed by the responsibility and the obligation to always put the best interest of the child in all the processes that we're dealing with. Then we also make use of special venues, Chair. I did make mention of the fact that we ensure that the children who are witnesses in these cases are not coming into direct contact with the alleged perpetrators, which are the teachers. And we also need to make mention of the fact that these teachers, they are allowed legal representation. I'm sure we've seen how the senior counsels, even in court processes, they tend to display a high level of aggression, such that the witness can be easily intimidated. Now you can imagine when you are dealing with a child who has already been traumatized by what they experienced through the actions of the teacher. Now they have to be confronted by a senior counsel who uses a language that is intimidating to the child. So we make use of these special venues to protect the children from, one, hearing what is being said by this lawyer and how it is being said, but rather the intermediary gets the information and crafts the question to the level of the child, so that the child can begin to recall what had transpired and be able to say. Then in turn, the intermediary transmits the information to the arbitrator and the other parties that in the common vein. What we also do, Chairperson, in the process of conducting this inquiry, our arbitrators are instructed to comply with the provisions of the Children's Act, wherein we are required to conduct an additional inquiry for purposes of determining the suitability of that individual who would have been alleged to commit this misconduct, insofar as whether they are still suitable to work with the children, and make the finding. And when that finding is made, we then have to report the same to the Director General for the name to be added to the Child Protection Register. Chair, again, this is one aspect that we need to clarify, because we always observe the comments made by the respective parties in this space. There seems to always be a confusion between the Child Protection Register and the Sexual Offenders Register. The Child Protection Register, we automatically add the names of all the educators that the ELRC would have found guilty for these type of misconducts. And we do that by informing the the Director General of the Social Development. We have no control over the Sexual Offenders Register, because for the name to be added on that register, the person must have been found guilty and convicted by a court of law. the ELRC, notwithstanding the fact that we are a quasi-judicial institution, simple put, our awards can only be reviewed and or set aside by the court of law because they enjoy the same recognition as the court judgment. So therefore, anyone who is not happy with that award, it is final and binding. There's no process to appeal, but there is a process to review it in the court of law. So you would remember previously, or even now, there are certain instances where educators would have been dismissed. For example, financial misconduct. That educator still has the recourse of appealing internally to the MEC and so forth. But the ELRC's award in respect of, and even in terms of misconduct, if it's an internal process, you can still go and appeal. But once we issue an award, you can't appeal anywhere other than going to the labor court and apply for the review and the setting aside of that. Chair, we also inform and notify SACE of our outcomes where we have found the educator guilty, and we request them to pay attention to that and process the same in accordance with their own processes. And what has been worrisome to ours is that in most of the cases that we have referred to SACE, because the parents are refusing to have the children subjected to secondary trauma, they do not send the children to SACE processes, and as a result, SACE is not able, they notify us that they were not able to remove the educator from the role and find the educator guilty because the learners would not have gone there. But they will talk to that chairperson. It's a matter that we think that the legislature should pay attention to, because ours, when this collective agreement was concluded, we had wanted to put in place a process that's going to protect the children from these different forums that they need to go and appear to and relieve the whole trauma. But equally, we do respect the fact that SACE processes are regulated in terms of that piece of legislation that they will be talking to. Then, Chair, there's another aspect which we have been communicating to the departments of education, the 9 as the employer, that once there are these allegations that have been brought to their attention, even before they refer the matter to the ELRC, they have an obligation in terms of Section 54 of that Criminal Sexual Offences and Related Matters is amended to notify the law enforcement authorities, failing which there are penalties. There's also a sanction of wherein they can be incarcerated. And that is another aspect that we are not in control of. We received a query from the Commission for Gender Equality asking us about our role in that regard. And we explained ourselves that we don't have control there, because if you look at what stage of the process do we get involved? We get involved only after the employer shall have conducted the investigation. So we hold the view that the employer, at the time of being informed, they need to then notify the relevant law enforcement authorities. Chair, what interventions have been put in the sector as a whole? There's an SOP in terms of reporting, and I think the department may have briefed the committee on that, but all the role players are aware of the existence of that SOP, and ourselves are included. SACE is there, the DSD, as well as the SGPs. Then another intervention, Chair, is that there is a policy in place that regulates the how you process these educators who would have been found guilty for this type of misconducts, wherein they are not to be re-employed. And this is an area that we need to strengthen, because the other aspect that I may have omitted is the fact that we do not have jurisdiction to deal with the allegations that involve teachers who are employed by the school governing bodies, because we only recognize the state as the employer. Likewise, Chairperson, I think as the legislators, you need to pay attention to what is the situation in the private sector. In the independent schools, there have been calls made that we need to intervene, and unfortunately, as things stands, the legislature does not give us the legal grounds to deal with them because they are the independent schools, but the Constitution also enjoins them to pay attention to that which affects the children. Chair, if you are dismissed, this one is the policy itself. They have already spoken to the educators. Under no circumstances should they be re-employed. But the tricky part here, when you are to implement this, is that the requirement for the teachers to be employed, especially those who would be employed by the private schools or independent schools, they must have the SACE certificate. Now, a person would have been found guilty through the ELRC process, but SACE does not find them guilty. They have the SACE certificate, and there are issues that have been expressed by the 9 provincial departments on the frustration on accessing the registers that are out there, which means without them having access to the registers, they would then rely on the existence of the SACE certificate, and that teacher finds themselves back in the system and they commit the same offense. Chair, I think this one just summarizes what we do. We submit the report to SACE, we submit the report to the social development, and again, I've also made mention of the fact that we have no way of testing whether the names are being checked against the register we have control over insofar as reporting is concerned. We also don't have assurance whether the alleged perpetrators are checked or reported in terms of the requirement insofar as Section 54. The other challenge, which Chairperson is a big concern where we are, there is a lack of reporting by parents. There are allegations that some parents get to be bribed by the alleged perpetrators, and as such, the case would be withdrawn because the kids are no longer willing to come, and the parents would insist that the kids must not come and report. And this is one area that we are working tirelessly to ensure that we run campaigns to create awareness. There's also allegations around mistrust, because there are instances where the learners will be alleging that the matters are being reported to the departmental officials and the principals, and no actions are being taken. I'm sure the recent social media reports have also confirmed the same, where kids were coming forward to say this is what has been happening in the school and nothing is being done. So this requires a joint effort from all those who have an interest of protecting the rights of the children. Chair, we're just sharing the statistics there. We're saying since we had this collective agreement in operation, we have received a total of 469 cases. The agreement came into operation in the financial year 2018-19. The graph sort of gives you an idea of the prevalence of the referrals province by province. And out of we have issued 211 in total awards, and we found a total of 176 educators guilty, and the 35 were found not guilty. And just to re-emphasize, all these cases where we have found them guilty and we have found the educators unsuitable to work with the children, we submit to the Department of Social Development for the name to be added on the Child Protection Register, and we also notify SACE of that. We're just listing there the institutions and organizations that we collaborate with. Of importance is the Department of Justice and Constitutional Development. I did mention that we make use of them to train our intermediaries as well as our commissioners who are dealing with these cases. We also work with the South African Judicial Education Institution that is responsible for training your court officials that deal with this type of cases. The DSD cannot be overemphasized, says the DPE in terms of us running campaigns, as well as the Commission for Gender Equality. We also work, Chairperson, with the NGOs that are operating in this space of protecting the rights of the children, and we have run campaigns. I thank you very much for your time, Chairperson. We will pause there as the ELRC and be guided by yourself. Thank you.
Thank you very much, Cindy. Thank you very much for that elaborate presentation. And I think one must appreciate how the Council has really sought to explain fully, comprehensively your role, your jurisdiction, and the authority that you have, and the different types of legislations that establishes the council. I think it will be important that we allow SACE or members. I am at your hands. If you would want us to firstly deal with the presentation of the ELRC and conclude that process, and then come to the presentation of SACE, or if we want to take the presentation of SACE and then we then ask questions to both councils. Members, what do we prefer? Process will make this process more interactive. Honorable Law.
No, thank you very much, Chair. Chair was proposing that we allow SACE to proceed, and then we will therefore combine and get to discuss all the presentations for the sake of time, because I think we still have a house sitting.
Ngobeni agrees that the hand was for that. So we are payment in this discussion. As who's in? Over to you, SACE.
Thank you very much, Chairperson. I think I've done something wrong with the presentation. Oh, okay. Here it is. Thank you very much, honorable members and Chairperson, and also our colleagues from the department and ELRC. Chair, we are presenting to you in line with the brief that we received. But before I go there, let me deal with the SACE delegation. Remember, the minister still has to finalize the appointment of council, but we are almost there. We having the CFO, Mr. Maurice Mapindani. We having the head for registration and induction and certification, Mele Chaba, Yvonne. We have the manager for planning, monitoring, and evaluation, but who's also acting as the head for ethics and professional development, Mayor Tuzana Sopete, and also our managers that are dealing specifically with ethics issues in terms of cases, but also professional development and the entire professionalization. Mayor Nomfundo, Matebula, Mr. Shekwambana, and also Mr. Njalinjai. So our presentation, Chair, in terms of the brief, was to focus on issues of teacher professionalization interventions, and it was specifically referring to those activities and programs for professional development of educators that SACE is dealing with. But also the request was to focus on the submission of register for sexual offenders, and I think in line with what the ELRC has already presented, we will also at the end align ourselves to that. And there was an issue around the code of good practice, which in our case, we use code of good practice in terms of our providers. And we are indicating, Chair, that the work that we're doing in line with those areas that have already been mentioned in the brief, it's grounded or based on building a capable, ethical, and developmental teaching profession. And I think you would know that this is in line with the priorities of the 7th administration, and that's the area that we're working on. Our mandate comes from the National Development Plan, which is giving us 2 or 3 critical areas. One is about quality management of provisioning of points-bearing continuing professional development, and that would include the SACE credit-bearing programs and qualifications. Because often when we talk about continuing professional development for educators, people will limit it to your short programs, your workshops, your activities that are related to your 1 day or even half a day and all that. We need to make it very clear that this quality management also for endorsement and also for approval of providers include your SACE credit-bearing programs and qualifications that are on the National Qualifications Framework of SACE. But the second area, which is also reflective in the SACE Act, is the issue of professional standards of the profession in terms of dealing with the internal quality of what it means to have qualified and quality educators in the profession. The SACE Act is very clear that we need to promote continuing professional development by managing a system for those programs that are submitted to us. But even in addition, we need to really be setting and protecting and maintaining both professional and ethical standards, because registration, yes, we deal with registration, but at the end of the day, for the rest of your stay as a teacher, there's a very important that you participate in continuing professional development that is quality assured by SACE, but also participate in or making sure that you adhere to the ethical standards and also professional standards of the profession. And therefore, SACE broadly has got a legislative mandate to regulate and professionalize the teaching profession. And as we do that, we want to make it very clear that we do it across the teacher education, induction, and development continuum. It's not about your practicing educators only. It's also about those student teachers that are there in higher education institutions who will graduate and be inducted and then participate in continuing professional development. Our 4 regulatory instruments, obviously, is the Code of Professional Ethics in line with the mandate on setting ethical standards and also professional teaching standards, as I've already indicated, SACE registration processes, as well as the management of continuing professional development, which is part of the what we call continuing professional teacher development management system. So these are the 4, if I may say, Bibles that educators must make sure that they adhere to in as far as that is concerned. So we are also indicating that as we align the work with building a capable, ethical, and developmental teaching profession, we also need to make sure that we link that with our impact statement, which is about enhancing public confidence in the credibility of the teaching profession, but also from a professional teaching standards point of view, we view it as a blueprint really for building a capable, ethical, and inclusive South African society. And that can only happen if educators really are adhering to both the professional teaching standards and also Code of Professional Ethics that is there to make sure that we safeguard the interests of the learners, we safeguard their dignity, rights, and also safety through our processes. I've already indicated that our teacher professionalization is across the continuum, so you can see what that continuum consists of: initial teacher education, mandatory induction and mentoring, and then admission to the profession and continuing professional learning and development as part of a lifelong process that they need to deal with. Now that we understand the role and also our mandate, our teacher professionalization framework is broad in terms of the first three areas that are highlighted in green are focusing on initial teacher education. They're about saying, what kind of a teacher do we want in South Africa? What kind of programs that are being accredited by Council on Higher Education do we have? Are they fit for purpose? Are they responsive to some of the things that we want to see happening in our schools? Are they aligned with the SACE professional teaching standards and also the Code of Professional Ethics? And even with the student teachers, they need to understand the profession, they need to understand the code before they can even graduate. So the entire process is about that particular area and moving towards registering them from year one when they become student teachers. The yellow area 4 to 6 is about saying when they graduate as newly qualified educators, working collaboratively with the Department of Basic Education and by implication 9 provinces and other independent schooling employers, how do we make sure they are inducted and not leave them drowning in the profession? And sometimes that is why they then leave the profession in the first 5 years, because of not having solid induction and mentorship into the profession. And therefore, your 4 to 6 are dealing with that particular area. So the area that is 4 to 6 until 7, where we designate them in terms of certification. The area that is aligned to what we are supposed to brief you on, it's 8 and 9, which are dealing with continuing professional teacher development system, which is mandatory. And part of that particular process is to make sure that we address professional teaching standards. We can't have continuing professional development that is happening in a vacuum. It must be informed by the professional teaching standards, and also we're moving towards having a 5-year periodic re-registration, but obviously this is a consultative process that we are working with the stakeholders in the profession and also unions in terms of how do we make sure that we deal with that continuing professional development in a manner that it's being reflected upon every 5 years through the re-registration process and all that. So this is the entire process of saying, if we are saying we are professionalizing the profession, what do we mean? But we also want to indicate that teaching is a relational process. And therefore, the Code of Professional Ethics as it is, we would see that it has got different relationships and also is viewed as a knowledge profession and collaborative profession. And again, I don't want to re-emphasize the role that the professional teaching standards will then play in terms of making sure quality is being dealt with, but also making sure we quality assure the provisioning of fit for purpose continuing professional development in terms of the approval of providers and endorsement of activities. We've presented the code before, and I think we know the 7 relationships that are there. We know that in most cases, people would think only about the relationship between learners and educators, but we need to remember there's a relationship between the teacher and the parent and the community, employer, and also the colleagues within the school. There are a whole lot of cases when we think about bullying that is happening between learners and learners. There's also bullying that we're not really talking about much in terms of teacher-on-teacher bullying. So something that we need to also highlight. Educator and the council and also the profession. So this is really what it means to be an ethical South African teacher. and also it's about peer-based accountability in the profession, being responsible, and also having professional judgment. The 10 standards, we've spoken about them. Values of the profession, I think every time when we present, Chair, we talk about them, and because you had the presentation, we would have seen them. Now, coming to the SACE endorsed continuing professional development programs and activities. Just to remind honorable members that, remember, SACE is not directly providing these programs to the educators. It plays only a quality assurance, a quality management to make sure that every provider, when they provide, at least they must provide fit for purpose, they must provide quality programs that are relevant, that are responsive to the kind of challenges that the sector is having. So as much as we showing them, it's only what we have endorsed in terms of the criteria that I've already spoken about: quality, fit for purpose, professional development programs, and also activities for early childhood practitioners, teachers, and also school leaders. Because of the priorities around, or the priority around ECCE, priority around broader early childhood development, we made it a point that the programs that we are endorsing are also taking into account the ECD practitioners. But all the providers also, before they can provide any program, they must have been approved by SACE against a particular criteria. And therefore, educators, when they participate in continuing professional development that has been SACE endorsed and offered by SACE approved providers, they will participate in 3 different types of professional development: those that they've initiated, those that are initiated by the employer and providers, and also those that are initiated by schools. And in doing that, they earn professional development points. And at the end of the, for 3-year cycle, at the end of the 3-year cycle, they should have earned 150 points. And we normally give them the certificates, which they use for different purposes: for national teaching awards when they participate, for promotional posts, and also other related areas. So the approved providers, in case of in terms of the SACE process, would involve or consist of Department of Basic Education, especially through Branch T and NICPD, because there are programs that they run there. Those programs, they come to us for endorsement. And the DBE as DBE also gets approved with the 9 provincial education departments as providers, and your SGB associations and school governing bodies as teacher employers, independent schooling sector, your national teacher unions. All of them, 5 of them, have got institutes, and therefore for professional development, therefore they become SACE approved providers. And even the work that they are doing with the Department of Education and 9 provinces in terms of teacher union collaboration, we make sure that there is quality assurance. We make sure that all the providers that they are using are SACE endorsed. Public and private higher education institutions, you would know that their programs are quality assured by Council on Higher Education. They are credit bearing, and that is why earlier on I said, even with those programs,
See, oh, you know that the 15 minutes has passed, right?
Ooh, okay, I'm rushing.
Passed some time ago.
Really? Okay, sorry, Chair. So these are the programs that then we would deal with. We've given you 110 professional development providers that we have, so that I've spoken about the criteria which you would have seen, and this is a spread of our providers within the country. The programs that we have, you would have seen that are 1,545 in the register, and this is the criteria that we're using. This table is giving you a breakdown of all the programs that we have in terms of starting from curriculum to teacher wellness to ECD to all the areas that we have in the system. But in addition, there are programs that we run ourselves in line with the mandate of SACE. You would have seen we prioritize ethical issues, standards, but also teacher well-being program. We do have practitioner and teacher-based colloquiums that we run within the system, and also areas that we deal with from a gender-based perspective for women. And the last part, Chair, that I want to focus on beside this one is the National Register of Sexual Offenders. Just this, in the same way that the ELRC has indicated, we don't have access to reporting directly. However, we do have access in terms of vetting before we can register. And therefore, one of the things that has been happening, we then have to send the cases that we need to report to police station. The subsite, they can't take them nationally. We need to go to the police stations across the country in order to submit them there and be able to, so that they can be able to deal with their own processes, conviction, and be able to include them. These are the cases, Chair, you would have seen them in terms of the ones that we are reporting to both the Department of Social Development and also the Department of Justice and Constitutional Development. Thanks. I'm done, Chairperson.
I'm not sure whether we may have
Mr.
lost.
Brown, I think we've lost the chair.
I think we may have lost chairperson. I think she's back now. I see she's back on the platform. Chairperson, SACE has completed. Thank you. Members, in the interest of time, could we request that we maybe have one of the members to chair the session until chair has returned? Can we maybe get a mover and a seconder for a acting chairperson while chairperson is off the platform?
Good morning, Honorable Law and honorable members in the platform and the department. Honorable Brown, sorry. My name is Pretty Kabanchaba. I nominate Honorable Law to be a chairperson of what interim chairperson or
Thank you, Honorable Tabanchaba.
okay.
Could I have a second for that? I think Honorable Ngubeni is indicating that. Thank you, Honorable Ngubeni. Honorable Low, would you please continue? Thank you.
No, thanks very much, Dr. Brown. We would have agreed that we're going to now get discussion from members as we would have received our presentations, and the members should be mindful on the fact that we do have a house sitting as we deliberate, but members, can we get hands so that we're able to allow members to engage on issues that we got in terms of presentation. I think we should also assist the chair to get fiber, Mr. Brown, at Akashia, because we can't have such cards. On a lighter note, can you get hands for discussion, please? Members,
on the lighter note,
Chair.
On the lighter note, Chair, I'm back in the meeting.
Yes,
on
Chair.
the lighter note, I'm back in the meeting, but of course my network is very bad. And yeah, we should get that fiber. But you can continue, Chair.
Okay, no thanks. Honorable Lerato.
Thank you, Chair. Thank you, Chairperson. Mine, honestly, is just a question or a comment for both entities, because we've been through this process through throughout the weekend. The question that I have that has been bothering me, and I think it was not really well articulated with regards to the mandatory reporting for offenders in this regard. What I want to get a sense of is, when we have mandatory reporting, and then we've got are the people who, the professionals who are supposed to be the custodian of mandatory reporting, are they well trained in terms of filling in the forms? What must really go with the report itself? And then once it's handed over, the process becomes what? And I know that, of course, some of the responses we always get is, it's not our duty, it's somebody else's duty, but it's quite alarming. The other one is, honestly, in terms of the parents who are withdrawing the cases, or who are being, and I don't want to say being compensated, as the word was used another time. They can't really be compensated for having violated children. If in fact, these monies, what would be the process that needs to follow in order for this to also be criminalized? Do we have to change the law in particular ways so that that action becomes criminalized? Because it cannot be acceptable that parents can be complicit in the abuse of their own children. Ultimately, the state is the final custodian of children, and the interests of children are paramount, first and foremost, to the state, before it even flows down to those who have fiduciary duties over the children, which are the parents. And so I just want to understand and get clarity on that, and a very, sort of something more concrete around that, so that we can really see as lawmakers ourselves, how do we need to move forward in this regard. And I think finally, in terms of the recording of the offenders, or who are teachers, and we are hearing a lot of this, particularly in the work that I have done in the Northern Cape, with regards to teachers or professionals who come through the system and then do heinous things to children, but get moved around. So in other words, they don't necessarily get out of the system. They may cease to be actual classroom educators, but some of them have allegedly been given posts by departments as officials within departments. I want to get a sense as to what the prevalence of that is, and what would be the reasoning for that, because it can't follow that people get almost rewarded for wrongdoing in this regard. I want to get a sense as to whether this is a real thing across departments nationally, or is that just an isolated phenomenon that is happening in that particular part of the world? Because it can't follow that really should happen. And then finally, why is it that once a child can get impregnated, why is it that we're not necessarily following fatherhood in this regard? Because that would let us know whether the person who has impregnated the young person is a child of equal age, or if it's somebody who is their elder. And so what happens in that regard? I want to get a sense of that, because it's quite alarming that oftentimes these cases only get to come to light once most of the time the final marker becomes whether there is a pregnancy, which would say that the child has been involved in an act that may have violated them in that manner. I'll leave it there for now. Thanks, Chairperson.
Thank you very much. You were with the cutting as you were interactive, but I hope that you are well captured. For where you are not captured, I think they will see clarity, and then you might be able to be proactive to come and assist us, because I'm not sure we're a bit losing you on a Ngubeni.
Okay, Chair. I will wait for that. Thank you.
Honorable Sheriff.
Thank you very much, Honorable Low. Good morning to everybody on the meeting. I'm going to start with the ELRC. I'll go per presentation that we were given. If we start off with, I think it's slide 8, if I'm not mistaken. Yes, it is slide 8. There is different sort of penalties, if I could use that word for a lack of a better word, that speaks directly to, it's number 2. An act of misconduct is any person found guilty of sexual offenses against children and mentally disabled people. And the mandatory period of prevention from reemployment is until they are removed from the register. Now, I just wanted to find out what is the difference between this and number 3. Because number 3 then says that you are removed indefinitely from reemployment, whereas number 2 says until you are removed from the register. So if I can just get a clarity on what that means and how then do people go about to remove themselves off a sexual register. And my only concern is because this one says found guilty. So if you are found guilty, it means that the process had already taken place and a verdict has been given. So why is there a disparity between the two? Next, I want to find out, you spoke about the different NGOs that you're working with, but you only listed 2. And I wanted to maybe recommend, as Honorable Ngobeni said, we had a stakeholder engagement with Childline, Child Welfare, and Silk City, who really do a lot of work in schools, specifically around statutory rape. So I just wanted to check on that. And then on the SACE, I'm moving now to SACE. The first question is, how does SACE ensure that all teachers register? And then how do you ensure that the re-registration takes place every 5 years and the re-vetting? Because in the presentation, the CEO did mention some challenges around getting feedback, not getting the clearance certificate in time or the signed declaration, and internal capacity and delays. So how does SACE ensure that the re-registration and the vetting happens every 5 years? And then I would like to get some more information on SACE around slide 34. And that looks specifically at the number of cases and disciplinary cases that has been finalized, which is a total of 134. They have 9 cases that are withdrawn. So what is the reason for the withdrawing of the cases? And then on slide 35, it has a total of 612 cases that were processed and finalized. So if I can just get an indication of what's the difference between those two. Those are my questions, Chair, but I just want to say that we know when we deal with statutory rape and sexual abuse and sexual misconduct when it relates to educators and learners, this is a very big problem and a big issue. And I think what this weekend has taught me is that government is not prepared and not equipped to actually deal with the violence that children are facing, specifically around sexual assault and sexual abuse at schools. And Chair, it really worries me and is very bothersome when we get reports that state that there are so many challenges, and these challenges are very big challenges. They're not small Indiana challenges. A lot of them speak to not confirming or monitoring the vetting process. How is that even possible? How do we say that we can't even monitor or confirm that the vetting process has happened? And then these people are still teaching our children at school. The lack of reporting to SAPS is very concerning. And of course, the lack of reporting by parents and teachers and not moving the case forward is also very concerning. So from my side, I think we have a lot of work to do, but I'll leave it there. Thank you, Chair.
Thank you very much, Ndado Komani. Ndado Komani.
Chair, I think you have jumped me. It's my hand.
Oh, okay.
Yeah.
Manga, I'm the one sharing here. Ndado Komani, you're not going to use me.
A go leboge ke kgopela gore Mrs. Kwambani is my senior. Then so I will refrain and then allow him, I will come after.
No, I'm the one chairing the document. Bolela ntate.
A ke le tamišeng ka moka ka mo ngakong wa ga borena. Ke tamišile chairperson le chairperson ya letšatši. Ke tamišile ba ELRC le ba SACE. Ke tamišile ba mphato ka moka. Bao ba le go gona le gono ka fa. Ke laetše gore di-presentation ka moka re di kwele. Re tia leopo la kgoro bana ba kgoši ba itsotsoropile ba re fele lesedi gore ba re gapa ba re iša kae. Se se lego gona ke eme mo ke romme ke mokgatlo wa economic freedom fighters ke no ba ke nyama nko go feta molomo kudu ka go kwešiša gore ELRC has explained itself with its capacity that is not of the entity of the department, is an independent. We understand, but we see to it on most of their presentation, they are shifting the blame to SACE, in which we were expecting them to stand for their counsel, to bring up solutions where SACE is not doing right, or they think it is not doing right, in order to shift the blames. Like maybe now they seem to be spectators. I want to come to the point where they raised this issue of parents who are withdrawing cases with their children from the line. I just want us to familiarize ourselves with the case of Tues, but the fact remains I'm hurt, whereby the processes from the department, even from the police department, they were very poor, in which some of the parents it's not because they withdraw the cases because they are no more interested of their children to be in there. It is because of the procedure and the speed in which the cases are ran. We can revisit the case of Tues, where the matter have been waiting for both or that three departments to articulate the issue, plus the social worker inside, just to find that they have been running the thing with a chameleonic standard where the matter end up losing interest. I think we have to be supportive in order to blame the parents, because the loophole is from the department. They are too granted on all the matters that are brought to their books. Then so we actually don't have to subject the parents. There is no parent who can just see a thing to withdraw her child. We must look into it deeply. There is something that make the parents to lose interest, in which we have an example, in which is what will stop us blaming, but to attach or to apply some investigation, what made them lose their interest. And then on the other part, we actually have to understand or do a serious reconsideration in the issue of people living with disability. We have to come to a present conscious by ourselves that all of us sitting today in this Zoom room, we can tomorrow become disabled. It is very possible, as far as it is scientifically proven, that there is no any human being on earth that is living without the element of disability. Some of us, we have the intellectual disabilities. That's why when we talk, we look at those who have a physical disabilities. We think it's the only disability. We are appealing that we take the thing of disability very serious, because most of us, by taking it serious, we will be banking care of people with disability, because tomorrow we are going to be that. Especially when the old age is coming, you automatically become an disability. Then so it is important for us all to take this issue of disability very serious, in which we will be preparing ourselves to be in the field of people living with disability. And then on SACE, I just want to check on them to revisit their issuing of certificates. It seems like they've done that at the time of Paul Kruger, if it might be not a mistake. It's long ago. It needs you to revisit your rules and regulation of issuing certificates. There is somewhere, somehow, where you are not going aligned with the rights of this citizen of South Africa, or of protecting our children against teachers who have been committed sexual cases or some sorts. Then so if SACE can go and revisit their standard, I think it is somewhere where they can be able to identify or to rule permanently for those who have been found guilty to be off recorded on their line, or to be subjected from their line, not to come back to our schools, especially as the court of law have ruled that they are guilty. If they make appeal, they can make appeal, but if it ends up like that, I think it must be clear to the standard that they must be removed. Because by SACE maybe still keeping their certificate active, it is undermining the child's rights, even the parental rights. Then so I think if they can look into it, they will bring up, or they can make some amendment on how can they deal with their matters. And then on the ELRC, I just want to check on your point that you said you were awarded to 211, and then 176 found guilty. We just want to get the report, if maybe I've never missed anything online, that what happened with those have been found guilty, are still falling under the path of being qualified by SACE to go through their daily jobs at schools, or what had transpired on their guilty foundings. Ke moka ke rialo ke re modulasetulo wa letšatši, ga ke be selepe go mela, ke se ke ka ba ka rema le maswika, ke tla ba ka rema lekgomo tša ka mešate ngwana kgoši. Ke rialo ke re molete sekuba ka namana a pholwana ya serapolotšane, ke le lebogeng ka moka. Thank you.
No, ra leboga ntate Komane. Ntate Mkhize. Honorable Mkhize. Honorable Mkhize. Okay, I think Honorable Shugomani, I think Honorable Mkhize has issues of Wi-Fi. We were the second victim of getting a fiber also. Honorable Shugomani, over to you.
Thank you very much, Chair, and greetings to everyone who's here and who's also part of this meeting. The network issue should be attended to. It's a very serious issue and it's disturbing. It's also making our work not to be as smooth as expected. But coming back to the issues that are on the table today, Chair, we've got a serious problem of sexual harassment in our schools, where our learners are being sexually violated in our schools. are harassed sexually in our schools. And the people who are doing this, they happen to be their teachers, their principals, and to some extent also, of course, it's a learner-to-learner cases. And these cases, when they happen, majority of these cases go unreported. The cases that which we find now that were presented here before us by the ELRC, and to some extent that SACE also spoke about, I can tell you that it's few amongst many of the cases that are happening in our schools. Majority of rape cases that are taking place in our schools are not being reported. Majority of sexual harassment cases and sexual violation cases that are taking place or happening in our schools are not actually being reported. And we need to check the reasons why these cases are not being reported in their numbers as supposed to be. Our people have lost hope in our justice system. Our people, they see that even if they can report these cases, no one takes them serious, particularly our justice system. Our people have seen through cases that were famous and were well-known cases across the country that they received the highest protection of officials, people who should be the ones in the forefront of fighting for those cases to to its finalities. But those people happens to be the people who are protecting the perpetrators. We have seen this with the case of Tues. But this person is disturbing. Can you call this person into order? Remove this person from the meeting. I'm speaking here.
No, yeah, can we mute that person who's disturbing Honorable Chukwamani, please? And can we mute all our gadgets so that we do not disturb, because we are streaming, and the benefit of the community must be that they would want to hear what are the issues that are raised and how are we going to push. So we apologize, Honorable Chukwamani.
Thank you, Chair. So we have seen with the case of Tues where the issue, it was reported, the Ministry of Police was also amongst the people that were in the gallery playing the game, that which we have all observed in that case. The mother came out, cried loudly for help. People of South Africa and the officials, all the departments involved, decided to keep quiet on the matter. And then how do you expect someone from the rural area, someone from the school, which is in the villages, deep rural villages, when is sexually violated by a teacher, to come out and speak and say, I am sexually violated by a teacher or a principal? Majority of teachers who are committing, who are even in the relationship, who are dating learners, those that which they are teaching them. We've got a lot of them in our schools, and that thing on its own is a criminal offense. For a teacher to date a learner, that teacher should be removed from the system. That teacher must be charged. But these learners are not coming forth to report such things, because once they report, they become more victims, whilst they were already they become double victims, so to say, because our justice system, it has collapsed, because there's no one who seems to take these issues into their best interest and dealing with these issues in a manner in which it's supposed to be dealt with. We have these things of learner-to-learner sexual harassment and sexual violation, mainly because of the usage, or the majority of our learners in our schools, they take drugs. They go to school drunk. They consume alcohol before they go to class. And our teachers and principals there in the schools, they are aware of these things. But they're not doing anything to protect or to prevent these sexual violations and sexual harassment cases and the rape cases to happen from learner to a learner. They allow this situation to be normal. They've normalized this situation to an extent that even institutions that comes and report before us, they've normalized the situation. They will tell you that there's nothing we can do for as long as we investigate. After investigating, we send the matter to the relevant authorities to deal with the matter. No follow-ups as to what happens after. The ELRC says to us, no, we are dealing with these issues, but Tina, we receive cases from the department, which is the employer. The department would have done the investigations themselves and satisfied themselves. And after having satisfied themselves, then they'll refer the matter to us. After having referred the matter to us, we'll then deal with the matter ourselves and we take the matter to social development and also take the matter to SACE. But I got an issue, or I was worried when Miss Cindy was presenting here. And Miss Cindy says to us that some of the teachers that they themselves found guilty happen to remain in the system and even be re-employed elsewhere and back to the system and continue to teach. And consequent to that, they even commit the same offense that they've committed before. Why? Because SACE could not find them guilty while they were found guilty by the ELRCs. Then I see the gap and the loophole here to say we are dealing with all these problems, but these departments, these institutions themselves, they don't communicate to each other. They don't work together. They don't. You just submit and let things there, and the other one do their own things on their own without referring from what is being referred to from the other institution. I'm like, how do you then find guilty? You find me guilty as an institution, then you submit all the reports to the relevant authorities, including SACE. But on the SACE part, the teacher is not found guilty. The teacher continue to teach and continue to commit same offenses and harass our learners, sexually violate our learners, rape our learners, and also even date them and put them under pressure like that. Those are the gaps that we are actually faced with. But I was listening to all these two presentations before us. My concern is that, okay, we can hear your responsibilities. This is what you do. This is what you are assigned to do as institutions, SACE and the ELRCs. But my worry is that after having done all the work that you are supposed to do, is there any justice that the victim has received? We are told that parents do not come forth to report issues. Learners also do not come forth to report issues. I have highlighted so one of the reasons why parents are not willing to come forth, and so is learners are not willing to come forth. But we have identified these things as an institution. What are we doing ourselves? Do we call these kids and speak to them? Do we call the parents and try to show them the importance of them taking the matter forward to an extent of opening a case? Or we just say, here is the numbers, 200 cases needs to be taken to the police station. Whoever wants to take it, take it. And then they end up not going there because these people, I can tell you now, it's not only because they are being paid. There are teachers who are bullies. And these teachers, they stay with them in the communities, these people. This person is a bully in the community. This person is a bully in the classroom. This person is a bully even in the school. In the community is well known. Some of them, they are even killers. We have a case of I think it's a deputy principal, if not a principal in the Eastern Cape, who was running a brothel, who was kidnapping learners. That person is a danger to the society. And my understanding is that most of the people who are staying with that person around knows that this person, how dangerous she is. And she comes now and commit a sexual offense or a sexual violation cases or any activity of some sort, and we expect our learners to come out forth and say, I've been sexually violated by this teacher. while that person is well known of being a criminal, even outside the school premises. And no one comes close to these learners and try to show them to say, no, 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 no. We understand this is the issue. We understand the situation you are in, but for you to continue to be being protected, you need to report this matter so that the police can deal with this matter and the perpetrator can be arrested. Then you know you have received your justice fully. No, we leave it like that. It's like it's a tick boxes exercise where the department, the employer, do the investigation, satisfies themselves, refer the matter to LRCs, LRC do their satisfaction, refer the matter to the relevant authorities, including SACE, and then it ends there. We don't care about the real person who has been violated, the victim on the ground, the trauma that this person has suffered. We don't care about that. This issue is worrisome. And then I think some new system has to be implemented and adopted, and we find a different way of dealing with these issues, because these are serious cases and this is affecting our learners on the ground. They are no longer learning peacefully. They are no longer enjoying the learning environment because they are surrounded by criminals and they're surrounded by rapists and sexual violators. I just wanted to highlight that, to say, to come and present here is not enough. To come and give us figures here is not enough. What are we doing? Because the real issue here is not being attended to. I'm not getting a sense where we are saying so and so number of people are being arrested from the cases that which we have found people guilty of. There's no such a report. And I'm like, what are we trying to resolve? What are we trying to solve if we don't have such report before us? As I conclude, Chair, I just want to check from the ELRC that what is the average duration of the arbitration process on sexual misconduct and sexual misconduct cases from the referral to the final award, that which you have received from the department. And then the other issue that which I want to speak on is that what type of a training or qualifications that are relevant to all the appointed arbitrators that you have to deal with or to handle these issues of sexual harassment, sexual violation, rape cases, and all those crimes that you may mention that are actually happening on minors. What type of a training are you giving to your, or are you looking at your arbitrators before they can be appointed as arbitrators? What type of training they must possess? What type of qualifications relevant they must possess? So, Chair, I heard when Umi Cindy was presenting saying that she feel like sometimes there is a misdirected anger from the people when it comes to this type of issues that which we are deliberating on here today. She gave an example that we'll find a matter will be reported or will be on public, and there will be a public outcry to say why is this matter not being dealt with, and the attack will be directed to the National Department of Basic Education. And she then says, no, that is a misdirection of anger, because the anger is not supposed to go to the national, it should go to the department in the provincial level, because those are the direct employers. There's no misdirected anger here. If I may want to correct Miss Cindy, there's no misdirected anger here. In your system, that's how it looks. In your system, that's how it looks. That the provincial departments are the direct employers. Therefore, the National Department of Education is not a direct employer, and therefore cannot be questioned or lied responsible for any matter that happens. No. Our people see the national as their last resort. When the actual employer, which is the Provincial Department of Education, are not doing their work. Because it is well clear that these departments are not necessarily doing their work. And who then must come to the rescue of our people when we've got sleepists in the department, particularly from the provincial level? The only people that we seek answers from will be the national department. And our people is not misdirected anger when they cry. And when they raise their concerns to the national must come down and wake up their provincial departments and make sure that their provincial departments do their work. It will be very wrong if we are going to say people cannot protest on any issue that may arise of national interest and take their protest to union building to the president because there's a minister of that relevant issue that that person must deal with. When people have tried all avenues and tried everything and they can see they're not satisfied, they will have to go to the president because the president is there. When our people have tried everything, the case of Kwekwe, that which we know, the mother have tried everything, no one has assisted that woman. Even today, we don't know where she is. We don't know how is the child. We don't know whether they are safe. We don't know whether they are dead or what. So there's no misdirection of anger here. The anger is well directed. It must be directed to both province and national, and both province and national through their systems and operations. They must make sure that they attend to all matters of our people. Thank you very much, Chair.
Thank you very much, Honorable Nkize.
Thank you very much, Muchavisegi. Zikeza ngare maningi nyona kuri kibulabule ka platform lay. Thank you very much, ELRC and SACE for your presentation. I just have the following questions and comments. I'll start with ELRC. You are saying from 2018, you received around about 469 cases. But if you check the period from 2018 to 2025, that is 7 years that has passed. And the reason why I'm paying attention to this is because we've been receiving information that sexual violation is quite massive in schools and teacher misconduct is quite rife in schools. So to see so low data coming up from you get us worried, simply because we're also told that the reporting of these cases is quite very dim. It therefore suggests to me that you are having 469 simply because you have not received cases that are unreported, that remain unreported, therefore suggesting that vulnerability continues in the communities, in schools particularly, but unabated. That's my worry. So on that one, I would like to ask ELRC, have you conducted any study, perhaps a qualitative study, to establish a proper baseline to the extent of teacher misconduct, so that you could be able at least to use that qualitative baseline against the quantitative statistics that you are having to at least see how much the gap is? Because at a certain point, we have to close that gap. We cannot be satisfied by a wrong, uninformed baseline of 469. Understanding the problem on the ground, as we have received reports from different institutions. It literally says to us, 469 is a gross under expression of reality. So the fact that these numbers don't come to you, it means there should be some innovation to make sure that more and more cases get reported. On that, I would like to ask, what is being done by SACE, DBE, and ELRC to upscale the reporting, to see more numbers coming in? So specific innovation there, I would like to be told. But if all these three institutions feel like there's no solution right now, I'll wish them to be honest and say there's no solution in making sure that we see an increase in reporting cases, considering that there's evidence that violation is existing in schools. Second point, Chair, It's relating to the first point because I want to understand what data contextualization that has been made says. And what do I mean by that? If you look at that slide, which shows that KZN is leading for 2025, 24-25 period, I think followed by the Eastern Cape. But other provinces are showing very lower numbers comparatively. When I speak about data contextualization, I speak about the analysis that is done to understand why there are lower numbers reported in province XYZ. Is it because they are suffering from underreporting of cases? Hence, we're having smaller numbers coming from them? Or it's because there's no teacher misconduct in that province? Because it happens that you think the problem is with a particular province, looking at the huge numbers coming in, not in a particular province, looking at the size of numbers not coming in, then you think the other province is doing right. While in actual fact, Chair, it's simply because the province with higher numbers is doing well with reporting. It's not because it's higher than the others. And the others are not actually lower. It's just that they're not reporting. Hence, the numbers are showing at a very, very minimal level. So I want to understand from i.r.o, how have you done data contextualization analysis? Is KZN and Eastern Cape, KZN and Eastern Cape provinces higher simply because there's rife violation, misconduct there, or simply because there's proper reporting happening? And the same applies to the provinces which are showing smaller numbers. It is smaller because there's good behavior, or it's smaller because there's poor reporting. That's the second question. Third question, Chair. I just wanted to confirm if SACE resolves issues of teacher misconduct through CLRC only. They don't deal with them personally, but I think as an institution, but I think that point has been made just to confirm. And if that's the case, CLRC, I think you owe an explanation to this committee as to why you are suffering from such huge backlog of resolving cases of teacher misconduct. It has been reported numerous times that we are having a huge backlog. SACE reported this to us in the previous meeting. So because CLRC is an implementer, perhaps to CLRC to share with us why there's a backlog. Is it based on issues of technicalities, legalities, or HR-related or operational issues? And perhaps SACE should also reflect on that. What is the actual cause of this backlog? And not only tell us that, also tell us what practical innovation you have put in place to deal with the backlog. And if there's no practical innovation, please be honest to the committee and say there's no effective innovation that is helping us to deal with the backlog. I don't want the stories there because the stories they end up hiding true meaning that we need to deal with, reality that we need to deal with. So if there's innovation to deal with the backlog, just state it and tell us why you think it's effective. But if it's not there, just say it's not there, so that we can make it as a finding, as a committee to say, we need to find a solution on that one, and it becomes a focused area of operation for us, strategic operation for us. Third question, Chair, I think is the fourth one. Is there anything done practically? I think Oram Skwamban also highlighted this. Is there anything done practically to prevent the perpetrators or the former perpetrators to get back into the system? To prevent them permanently, just they don't go back, whether they go to Eastern Cape or they just don't. Is anything done to make sure that they don't get back to the system? If there is, please state it. If there's nothing, say there's nothing. If there's something not effective, state there's this thing, but it's not effective because of 1, 2, 3, 4, 5. Specific answer on that one. Next question, Chair. What is done by those? What is done to those who fail to report sexual violation of learners in school? We know that we are having section 54(1)(a), which makes reporting very mandatory, and section 54(1)(b), if I remember very well, which makes it illegal not to report sexual abuse. So I want to understand from DPE, perhaps SACE, I know you deal with teachers and ELRC, but as the team that works with the same issue, what is done to make sure that those who fail to report, they are taken to task? If there's nothing being done, please state it. There's nothing being done. So we know that there's a gap and we need to address it. It's very important for us to do that. And the concern I have on that same point, Chair, is that the presentation said there's an allegation that the parents are bribed. I think we need to move a little bit forward. Let's move beyond the level of allegation. We've got police in South Africa who can investigate if something is true or not. So if we allege that the parent has been bribed, thus discouraging the child from pursuing justice, that parent should be investigated to establish why the parent is not supportive of a noble action to administer justice to the child, so that the parent herself or himself can take accountability. We cannot be comfortable with allegation. We use allegation as facts, but we still state them as allegations, and in the process they become a baseline of failure. So there is a weakness, you have identified it, verify it, then take action. I need some closing of that issue. After alleging that parents are bribed, what do you do? If you do nothing, say we don't do anything, then we'll know that nothing's been done about what needs to be done to improve the situation on the ground. Say ELRC. So the other question, ELRC, what makes 20% of alleged perpetrators? What is a common factor which makes the 20% of alleged perpetrators to be found not guilty? Because I know there could be some disaggregation happening there. To say that 35 that you found not guilty, what was the dominant reason for them not to be found guilty? And why I'm asking, in the sitting yesterday in the Eastern Cape, we're told that most of perpetrators run free simply because there's lack of evidence. So I want to test if that is the common predominant factor or the other factors, so we can innovate around that one. It's all about finding the holes, colleagues, and close them up. We can't keep on reporting on these holes perpetually, but we're doing nothing about them. Let's identify them, characterize them to the final dot, so that we know what kind of intervention is required. So please disaggregate the 35 not found guilty for me to explain what was the dominant factor that led them to be set free. Is it because the perpetrator lied? Is it because there was no scientific evidence, empirical evidence of rape? Is it because there was withdrawal of case? We just want, there was lack of participation by the alleger, perhaps, something like that. But we need to know the characteristics of data for those who were not found guilty. I have only 2 questions for SACE. One, names removed indefinitely for those who were found guilty. Why you are using word indefinitely? Because for me, that word means for undefined period. Why you are not saying they're removed permanently? Is it the law that says you cannot remove a person permanently even if the person raped a child? Because if you say indefinitely, you are giving a hope to the perpetrator, not to the sufferer. So can we move to a language which says removed permanently, if that is allowed in terms of the law? If it's not allowed, where's the gap legally, so that we can sort out that gap, because we need these people to be removed permanently from our system. Last point, Chair. Number of cases finalized are 612. So what I want to understand from SACE, against what baseline? Because you're reporting here, you are just telling us the numbers that you have received and you're using them as a baseline to measure your performance. But tell us, Suti, you say you resolved, you finalized 612 cases. Against what numbers which were received? Cases. Because you want to match, because you could have received 5,000 cases, but you only resolved 612, which literally means you're underperforming. But we can't see that underperformance from this angle of reporting to only tell us about the number we have resolved. But you don't tell us about the actual number of cases received for us to calculate the percentage of your performance. I sit down, Chair. Thank you very much.
No, thank you very much, Honorable Mkhize. Thank you, members. You've raised important.
Honorable Chairperson, sorry.
All right.
Sorry,
all
Honorable
right.
Chair. I can't raise my hands in the gadget. I'm
No,
in
yeah,
another gadget.
Yeah, we'll take you to an ITC training next time for you to do that. Over to you, Ma'am Kaba, on a lighter note.
Okay, thank you, Chairperson. Chairperson, let me welcome all the presentation, and also I'm strongly concur with my honorable members who raised the issues of these 2 departments were presenting. Yes, I'm supporting it because, Chair, yesterday We were in Eastern Cape. In the Eastern Cape, there was an issue that came up to the presentation, to the presenters that were presenting before us. That issue says there was a female who went to the police station to register a case to the police in the police station. The police refused to take that case. I'm raising this. Actually, I was saying to me, I won't say anything today to these presenters because even if you can say something, there will be no solution. There will be no thing that they'll come and tell you that no. Now we resolve this, we resolve that. As Honorable Sikwamban and Honorable Mkize, they are saying. Now, Chair, in that Eastern Cape, they know this police station, they know the family, the presenter that was presenting to us about telling us that when they were opening the case, the police says, I won't open the case because there is no case here. But the child was raped. The case was there. But he says there is no case here. The police. Okay. When I asked the question, there was no answers. Chair, that is why I'm saying to I was not wanting to even to participate because I'm still hurt about that issue that I got in Eastern Cape yesterday. So, okay, there is no case. I'm saying, Chair, maybe these department presenters, before they came to us, they must research about the issues that are being resolved, about the issues that are sensitive, about the issues that they were not resolved, but they are keep on touching the police. Because the police, they are not magistrates, they are not judges. They cannot judge a victim. When a victim came and opened the case, said, no, this case is not a case. Who told them that is not a case? And then who told them this is not the case? Because, Chair, if you can see this thing clearly, this issue is with the police. Our police are not strong enough to deal with these issues of our children and mothers and young boys. Because yesterday I heard that there was two boys who were raped. Our police, they are playing our laws sometimes. And even us, but Chair, the people of rural area, hey, they are the vulnerable of these issues. They are the really vulnerable because sometimes if this police station next to me in the rural area, they refuse to take my case. I don't have money to take a taxi to go another police station because it's very far. Now that is why our people involved sometimes let's recommend them. What is this? This Smolanyana police station. There is a way of English bakithi ngikhumbuzeni isiZulu sithi mahamba nendlwane. Lama police station satellite, yes. We must recommend many satellites in all rural areas so that people they will be safe and safe to these criminals who try to be smart to them while they are killing them silently, emotionally. Thank you, Chairperson. But my question is that in these presenters who are before us today, did they know anything about the case that I'm talking about now in Eastern Cape? Because that issue was in the Eastern Cape, we were in the Buffalo City. I forgot the name of the presentation. The what is that one? It's the NGO. I forgot the name. But those who were there yesterday, they can maybe help me to If they know nothing, if they know anything about this case that I'm talking about, that there was a case that was not opened because the police refused and chased them in the police station, they must tell us if they know anything. I'm not saying they know anything. I'm saying if they know anything about the case that the police was refused to open, they must tell us so that we'll make a follow up. In that case, I'm very curious to know that police who did this in this family, because they are suffering, because they are poor. Thank you, Chair.
No, thank you very much. As I give back to the chair, I think it is clear that the engagement with the Provincial Education Department is a necessity on our members, because that's where the weak link is in the ecosystem of accountability and consequence management for teachers' sexual misconduct. And the recent development, I am quite concerned, because already when I went through the documentations, one would have said that there's an intensified concern about sexual misconduct by educators in South Africa. There are multiple agencies in across the country now who are facing court action for failing to implement child protection mechanisms, while the new cases demonstrate systematic failures in vetting, investigation, and prevention. So we are centered whereby our vetting, our investigation and prevention, it's linked or it's intertwined to the departments that they should play oversight to. So I want to further highlight to say, in the recent October already, Chair, we would have had a cases that were reported where a Soldam teacher and a co-accused at the age of 45 were charged with sexual rape and of two boys aged at 16 and 15. A former Harvester primary school teacher was also charged, Chair, with the sexual grooming and exposure of explicit material to a grade 7 learner. I'm speaking about October 2025. And a sexual misconduct allegation at Eastville Primary School involving a school volunteer under investigation, Chair. And then the ELRC also received in about 6 cases of alleged sexual misconduct in the Western Cape that were in between April and October 2005. SACE is reporting 606 misconduct cases, which is almost to 148 that are indirectly related to sexual abuse. And lastly, when the AG was here, he raised an issue of failure to adhere and deal with cases. It's a backlog, it's a problem. It demonstrates that we are not quite committed on essential issues that needs to protect. It means we've got good laws in paper, but when coming implementation, we are failing our children, we are failing the vulnerable families who do not have the means or adequate resources to respond to this epidemic. Section 27 Teddy Bear Foundation has already taken us to court as government, to Gauteng High Court, challenging the failure to maintain and implement the National Child Protection Register, because we are failing to vet teachers. We are forever in a backlog whereby the vetting of teachers is waiting forever there. And the said people who are doing this thing to our children are the same people whom are the teachers of the children, Comrade Chair. You would find out that in most of the educators who are hired without verification against the national registration, it's happening. And the department is there. And the department is aware of the backlog. The manual vetting system is putting capacity constraints to the Department of Justice, and it creates delays in the provision of the registration for such. That's our problem. And then it brings a serious risk of employment of known offenders, because we are going to hire everybody, will create a crisis. So we need to protect our children. We need to deal with this particular issue so that we're able to be responsive. So if we're able to seriously collaborate and seriously deal with issues, I want to agree with Honorable Sheriff also. Well, from a stakeholder interactive engagement weekend, chief to the engagement that were discussed there is that we are failing to implement, we are failing to protect, we are failing to be proactive. We are good in paper, we are good in presentations, in compliance, but if there are backlogs of cases, that means we are not moving, we are doing nothing. We need to be moving away, because the children who are in the rural areas who do not have the means are the ones who are suffering. I'm repeating. So we need to see how we become responsive, and then what becomes corrective measures and recommendations, because I think members have already held much, Chair, on key issues of importance and how we should deal with issues. And my primary concern, which I would want to engage SACE with, I think SACE needs to establish an integrated database link SACE, DBE, the Department of Social Development, and National Register of Sex Offenders to streamline the vetting and registration of misconduct tracking. We need to have that. We need to expand teacher-led research, and we need to ensure that the professional standards evolve through practitioner input. It's quite important. We also need to expand. We also need to shift from point-based compliance to evidence-based professional growth, what recognition for innovation and classroom impact. We need to do that. SACE must focus on that. And we need to ensure equitable access to CPD for rural and under-resourced schools through mobile and blended learning chair, so that we're able to respond to all of these issues that are confronting our institutions, and who are responsive in a particular way. So I would want to pose questions to SACE and move to ELRC so that in the interest of time. How is SACE ensuring that the code of professional ethics is fully understood and internalized by educators and student teachers and social leaders? How often? What are the programs? What are the advocacies that have been ran through this program to be able to enforce, so that we're able to deal with the backlogs, because it also goes with how we deal with situations? And can SACE provide details of the professional development pathway from provisionally registration of student teachers to full registrations and periodic recertification? We need to know about those things so that we're able to see. And how we SACE promoting gender equity and women's leadership within the teaching profession. SACE must be able to tell us and be clear about that particular way. Let's move to ELRC chair. I think ELRC has presented their report. And in their report, they identified that many learners and parents refuse to participate in the DC or SACE hearings, primarily because they want to shield their child from trauma.
Recording
and secondary
stopped.
trauma, because this reflects the finding that was done on 2018 by Richard that says that the argument is that the child victims or educator abuse, they often experience a traumatic way whereby they are not able to be dealing with these situations, by virtue of saying that, like I said earlier, the teachers or the people who are involved in this particular way remains the people who should be taking care of the children. Hence, I'm recommending that they should be collaborative way, that are means of proactiveness and responsive to the way that we're going to ally. And I think LRC needs to strengthen its approach so that it develop a centralized national database linked to SACE, DSD, DB, and SABS records on educators found guilty on misconduct. That's what we must do it. And we need to establish provincial child protection task team to monitor compliance with reporting obligations. We also need to integrate a psychosocial service within schools, ensuring trauma counseling for victims and witnesses, and must provide safe reporting channels, chair. Anonymous hotlines and digital platform must be there so that we're able to trace, we're able to track, and there's consequence management. We see if we can enforce consequence management, and we must also say that both entities must have a tracker that traces consequence management, so that we're able to see, are we moving or are we, what is the progress, and there should be collaborative way quarterly. This department must meet quarterly, they must report, they must release stats, and they must share with the committee the stats to say we're moving from this particular way to this particular cases to be responsive in these issues. We need to incorporate comprehensive sexuality education that emphasize consent, gender equality, and respectful relationships. We must empower our learners through social-based safety committees and participatory workshops share, so that we're able to deal with all of these issues. I would want to ask 2 to 3 questions to LRC. What is the average duration of an LRC arbitration process in sexual misconduct cases for referral to final award? How does the ELRC ensure that hearings involving learners are conducted in a child-sensitive manner? What training and qualification do LRC appointed arbitrators and intermediaries possesses in handling cases involving minors? How does ELRC coordinate with the Department of Basic Education, SACE, DSD, and the Department of Justice to streamline reporting and follow-up processes? Are there any formal memorandum of understanding or data shaping agreements between these institutions to improve case tracking and accountability? If there is, I've recommended. If there's not, I've recommended chair. What are the key challenges encountered in interparental coordination, and how does the LRC propose that they be addressed? And then for monitoring evaluation, does the LRC maintain a centralized national database of all cases involving sexual misconduct accessible to SACE, DSD, and DBE? And how frequently an LRC process and outcomes audited for compliance and quality assurance? What systems are in place to ensure confidentiality and protection of child victims? And then what are the LRC primary resource and capacity challenges in managing sexual misconduct cases? Thank you, Chair. Chair.
Thank you very much, Dr. Cindy. Like, apology on behalf. There is a lot of questions and discussions, of course, asked, but I think is Dr. Cindy, you kept mentioning that there is legislative gaps. And where we are seated as a committee would really want you to sort of those legislation on exactly where are the gaps with the legislation that is in place. And I want to make an example of what you said, which for me is very concerning, where you spoke about the interface between the process that is undertaken by the ELRC and then the substance taken by SACE, because the two processes are important. So the ELRC's process, it's the disciplinary process after the employer, which is a PED, against an educator of a sexual misconduct or some harassment, and started, and then you find then the learner has to be there, because the learner has to be speaking about how this to the victim, this who has to experience a second violation moment over and be asked questions. You find the educator guilty. Now, the process and the processes of SACE, and you said that is because of SACE. It's because of the legislation, so that they can determine if that teacher guilty and must be removed. And for me, that's a huge problem. SACE then does the very same thing that you have done. Now, I see the message popping out that you are unable to hear me. Dr. Cindy, is it better now?
Hi,
Honorable
Chair.
members, am I
Sorry,
audible?
Chair. Chairperson, from my side, your input is intermittent. So I hear words, but I can't hear the full submission. Thank you.
Okay, is that the experience of all members?
It comes
Yes,
and goes, Chair.
from my side, yes.
Yes, Chair,
Correct,
my
Chair.
side too.
Correct, Chair.
Is it fine now?
No.
It's still not fine.
It depends from which angle. Where I'm sitting, it's fine. I don't know.
It's fine for now.
Okay. So I don't know, because on my side, I've now connected on my phone, because I really just let go of the Wi-Fi source that I was using, because I felt it was not reliable. So I'm using my phone, and I just thought I could hear everyone very well, even the chair. So I don't know. I do hope that it gets better. So my argument, Dr. Cindy, was that you need to be able to comprehensively explain to us through a report on where these legislative gaps are. Because when you were relating the experience of the council as it deals with disciplinary cases of educators that are alleged to have the processes of SACE, to say why is it that SACE Okay. There was somebody who was trying to say something.
Chairperson, we lost you for a few seconds, and then you came back completely again. So we get you quite clearly for a while, and then you do break at times. Thank you.
Okay, Mr. Brown, okay, fine. Let's do this then. Let me give an opportunity to the both councils to respond. I'm going to try and log off from the laptop and try and log in with my phone and perhaps move from where I am so that I can be able to complete my submission. But so that we don't waste time, I'm going to allow Dr. Cindy, the ELRC, and SACE to start responding to the numerous questions that were raised by members, and then I will make my interventions later if they are not responded to already. Dr. Cindy.
Thank you, Chair, and thank you to the honorable members for the questions and the comments. Chair, I'm going to try and respond to all, but you'll guide us if we've omitted any. But at the tail end, my chairperson, Dr. Bono, will come in. Chairperson, let me start off by clarifying our submissions. We never made comments or inputs that parents receive compensation. What we clarified was that our interactions with some of the provincial representatives is that there are allegations of bribes that are paid. And it's important, Chair, that we put that on record because we don't want to go out of this meeting and then the media runs headlines that parents are compensated. No, we said there are allegations. And we also need to appreciate that that comes to us in the form of hearsay. We get to hear from the provincial representatives. We are not in direct possession of that information insofar as us referring those matters to the relevant law enforcement authorities for appropriate actions to be taken, i.e. investigation. Chair, in terms of reappointment, I think the respective 9 provincial departments are better placed to respond to those questions. Because as I said earlier on, the mandate of the ELRC is derived from the Labour Relations Act, in particular Section 37, which establishes a bargaining council. The role of the bargaining council is to promote and maintain labor peace. Thus, that is done by providing a forum for engagements between the employer and the employee parties represented by the unions. And when disputes do arise, we resolve those disputes. I then, Chair, limited our input. I didn't get into details about our scope in particular because the brief was specific that we must talk mainly what is the role of the ELRC on cases of sexual misconduct. And I explained that is done, informed by the collective agreement that we refer to as the inquiry by the arbitrator on allegations of sexual misconduct, which is the operationalization of Section 188 capital A of the Labour Relations Act. It's important, Chairperson, so that we begin to appreciate the limited role that the ELRC plays in these issues. The ELRC is not in charge of disciplining the educators. This is an exception. It is only confined to cases where there are allegations of sexual misconduct. Any other misconduct committed by the educators, the employer has to subject the employee to a disciplinary process. And Chair, I want to link that to the backlog that would have been reported to yourselves by SACE. That has nothing to do with the work of the ELRC. SACE must come back when it's their turn to clarify the same. The cases that the ELRC deals with are not directly linked to the backlog that has been reported by SACE. SACE is regulated by its own legislation, which is not the Labor Relations Act, but the SACE Act. Therefore, their cases covers a range of issues. For purposes of today, the ELRC cases are only limited to allegations of sexual misconduct by educators, and the two processes are independent of each other. When we report to the portfolio committee as the challenges, we hold the view that SACE has made that publicly known as well, that when there are cases where learners are to appear before SACE, for SACE to be able to execute their mandate as enshrined in their piece of legislation, without those learners appearing in those processes, SACE is not able to confirm the outcome of an ELRC dispute and or award, because there is legislation that regulates the two processes, and the two legislation must be read independent of each other. So the intention was never to apportion blame to SACE, but it was to illustrate to the members of the committee that there would be cases that are finalized by the ELRC, but purely because, and I'm happy, Chair, because one of the members did make mention of the presentation that was received by the committee, where there were reflections on how we must all address the issue of subjecting the victims, which are the learners, to secondary trauma. That is the issue at hand here. And when I made mention of the policy gaps and or legislative gaps, I was referring specifically to how best the committee, as the members of parliament who are legislators, who are charged with the responsibility of amending legislation such that it does not frustrate that which was meant to address, but it facilitates. I was drawing that example, Chairperson, to illustrate to the members. The intention was never to say SACE is failing in their job. Likewise, at the ELRC, when the learners do not come and present the evidence in the hearing, the arbitrator is not in a position to make a finding of guilty against the alleged perpetrator. We are using the term alleged deliberately, Chairperson, because it is in terms of the law. Until proven otherwise, you remain alleged. When the case is finalized and there is evidence that has been presented and tested by that independent arbitrator, then the award will make the finding that the teacher is guilty or not guilty. In respect of the statutory rape, Chair, that too, I'm happy to hear that the committee is interacting with the provinces. That too must be directed to the provinces. The ELRC does not receive such information. Again, members are reminded our role is confined to a case that would have been referred to the ELRC by the employer, and that process is informed by legislation. We have no liberty to deviate and start venturing into matters that are outside the legislation. Otherwise, we'll be opening ourselves up to court processes, and we will miss an opportunity to deal with what matters the most, protecting the children of the country against those who are committing these types of misconduct. Chair, the question from Honorable Lowe, why are we talking to the period until such time you are removed from the register? I want to refer the members to Section 51 of the Criminal Law Sexual Offences and Related Matters as amended, which provides for the process of removal of particulars from the register. Again, appreciating that we are a constitutional democracy. A lower court might find you guilty, which comes with its consequences. But for as long as you have provision in legislation to go and appeal up to the apex court, which is the constitutional court, and if this piece of legislation provides for a process and or circumstances that a name can be removed, it stands to follow that any other piece of policy and or regulation must take that into consideration. Likewise, Chairperson, the Children's Act, your Section 128 of that legislation provides for the removal of the name from the register. Which register? The Child Protection Register. So all these issues that are tabulated here are informed by the provisions that exist on other pieces of legislation that regulates these issues that we're dealing with. In respect of the suggestion of other NGOs, we welcome that. As I said earlier on, ours is to say, for us to fight this cause, we need a collaborated effort from all interested parties. So we will welcome that and we will reach out to those organizations that have been identified. The other question, Chair, what happens to those who are found guilty? Chair, in one of the slides of our presentation, we did make mention of the fact that one, that educator is dismissed. Two, that educator's name is submitted to the Director General of Social Development for the name to be added on the Child Protection Register. The same name of the educator is handed over to SACE for SACE to initiate the process in terms of the SACE Act. We are in no way pushing it over to them. We're complying with legislation that has been passed by Parliament. When SACE invites the parents and the learners and all the educators implicated, they too are implementing that piece of legislation. The question, Chair, around learners, we have no jurisdiction over learners. I did make mention of the fact earlier on that we are a quasi-judicial institution. Our work is defined in legislation. Our limitations are defined or regulated by what we are to do. The outcomes thereof are also determined there insofar as what do you do if you are not happy. The issue around the gap between SACE and ELRC, I think I've spoken at length, that is as a result of them having to implement what is provided in their legislation, us doing what we can do within the confines of the law, in particular the LRA Section 188, capital letter A of the same. The average period of us dealing with that case, Chair, we can roughly say it's 3 months, but we're saying that with the greatest level of caution, purely because each case differs from one another. The Constitution of the country, which is the supreme law, guarantees every citizen a right to legal representation. When a person writes and applies for postponement of the case, as the ELRC, we do not have the legal grounds to reject the same if they give as an account for that request that my legal representative is not available on this date. So there are a range of issues. That postponement too, it's provided for in the Labor Relations Act, which is a piece of legislation that regulates the processing of disputes. The training and the qualification of the arbitrators that we are using, we require, Chairperson, that our arbitrators must be accredited by the CCMA. CCMA derives that authority to accredit any individual who's to preside over an arbitration. They derive that authority from the Act. It's the institution that is recognized to have that authority. That is number one. But their qualifications are legal in nature. Their training is on arbitrations, the presiding over arbitrations. Then I did make mention, Chairperson, of the additional training that we provide through the Department of Justice, which is now known as the Constitutional Department of Justice and Constitutional Development. And they have a special college that they use to train your court officials. That will be your magistrates who preside over these cases in children's courts. That will be your prosecutors. So additional to the fact that we appoint people who are legally qualified to preside over arbitrations, we subject them to this additional training on how to deal with the evidence of the minor. And that training is provided by the reputable college, which is established to train your prosecutors and the magistrates who presides in our courts of law. Then in terms of the research, Chair, I think I've already made mention of our mandate. If there's any research that is to be conducted by the council, the same must be initiated by the state, led by the Department of Basic Education, national and 9 provinces, and supported by all teacher unions in the education space that are recognized by the ELRC. That too is regulated in the LRA. Then, Chair, the issue around the terminology used, permanent and indefinitely, I think we, out of respect for the committee, we don't want to necessarily give the definition which suggests that it means the same. It's just the choice between the wording. But what practically means, it simply means that at no point will that individual ever find themselves working in the system, because the department as the employer blocks the personal number of that educator on the system. So therefore, for that person to be employed in public education, mind you, public education, not independent education, then that personal number will always be blocked. They will not find themselves back in the system purely because they've got that indefinite. And again, that too, it requires the strengthening of the vetting exercise, which is not the responsibility of the ELRC. The ELRC can be the referee and the player in these cases. The employer is to play its role, and we play our role within the confines of the law. Then what measures are put in place by the ELRC to ensure a safe space and that the learners are protected? Chair, I think in my slide 2, if I can refer you back there, I made mention of these issues. 1, the use of specialized venues. We also have access to the children's courts. That is as a result of our working together with the Department of Justice. They've given us access to those courts where practically possible, because they also have their cases to schedule there. In the event that we can't get access to those cases, we make provision of using specialized venues wherein these learners do not come into contact with the alleged perpetrators. I also made mention of the use of intermediaries, which are social workers by profession as well as psychologists, because they've been trained to assist a learner or a minor who is a victim to a traumatic situation, such that they are able to lead or present the evidence without any fear of victimization. I elaborated, Chairperson, further by even illustrating that the manner in which the questions are asked, the arbitrator and or the parties to the dispute, the lawyers and the union reps, will ask the question. The child does not get to hear what is being asked, the tone being used, and all that. That question is received by an intermediary who is in the venue with the child witness. The intermediary, utilizing the training that they've received, they take the question, rephrase it to a level of the minor, and further take note that it must be understood and the learner must not be intimidated and or threatened by the language used in the question being posed. Upon getting the feedback from the learner, the intermediary is the one who then relays the response of the learner to the arbitrator and the other parties to the dispute, in this case, who are the majors, because our duty is to protect the interest of the minor, which is the child. In respect of Chairperson, how does one access? I did make mention we're a quasi-judicial institution. All our awards are uploaded on the website. Anyone can access them. And in our awards, you will not find the details of the learner, but the details of the perpetrator are contained in the award. But the learner's details are concealed. You would not see who the learner was. So that information is there. The resource and capacity challenges, Chair, at this point in time, our challenge has always been access to the children's courts, and we have managed to find and or to establish a rapport with the Department of Justice. And we are doing very well at this point in time. Therefore, we do not have any specific challenge, but our request still remains. There needs to be an exercise undertaken to ensure that these pieces of legislation that have been promulgated by Parliament, they do not form part of the hindrance from that which they were intended to achieve. The issues around the vetting, I see no reason why can't there be an MOA between all the various government departments, being your SAPS, your Department of Justice, such that at the point of recruitment and or registration by SACE, the biometrics of that individual are run at no cost, and then the person is cleared if they are not cleared, or the person gets to be rejected. So that is a discussion for another day, and a discussion that will require those who work with those pieces of legislation, as well as the instruments that they are charged to manage. Chair, I think at this point in time, through your guidance, I will pause and request you to allow my chairperson, Dr. Luvuyo Bono, to cover that which he feels I have not covered. Thank you very much.
Thank you very much, Dr. Cindy. Dr. Bono, please, really in a summary, we no longer have time. Just a short summary if you want to add to the responses.
Thank you, Chair, and good afternoon to the members, honorable members of the committee. Chair, Dr. Foka has covered most of the issues that I wanted to to raise. I just have one, just literally one issue in the interest of time that I need to raise. I think there needs to be an understanding and appreciation of the different roles that are played by the ELRC and SACE, and also appreciation of the legal framework. In regards to the issue we are reporting on, we deal with misconduct. SACE deals with ethical conduct. These are two different things, two different processes, two different standards of proof, two different legal tools used to deal with these matters. And indeed, and I agree with the honorable member that spoke about legislative gaps. And once you appreciate those, then you can understand where the gaps are, and the committee can assist us in terms of closing those gaps in the interest of the child as enshrined in the Constitution. So if one can appreciate those, then it makes life easy in terms of dealing with all the other issues. And I think with that appreciation, one would understand that we're not shifting the blame. This is not the manner in which we deal with these matters is not a tick box exercise, and statements that we do not care are quite unfortunate in the manner in which they are raised. Chair, thank you very much, and that is all that I wanted to say. Thank you.
Okay, thank you, Dr. Pono. CEO SACE, I'm going to give you just a few minutes to respond. Please just ensure that you are a bit quicker with the responses. We are really running out of time.
Thank you, Honorable Member. Yeah. Now we'll see how I try and deal with all the questions raised. I think in terms of the issues around mandates, rules, and legislation, I'm happy that the ELRC colleagues managed to deal with that sufficiently. I'm not going to go back to those issues. But let me also deal with the issue of who reports our cases to SACE in terms of the legislation. Remember, anyone can report. It doesn't have to go through whatever channel, but also we're getting cases, as ELRC has already indicated, from them and also from all the employers of teachers in terms of Section 26 of the SACE Act, so that we can deal with, especially the dismissals, we can process them through the SACE Act and our own processes in order to finalize the issue of whether there's a need to strike off or not. So that's another area that I wanted to clarify. Mandatory reporting from our own side, if an educator, it is proven that the principal or educator did not fail to report a case for particular reason, we do charge that particular person. It's there in our Code of Professional Ethics, is there in our disciplinary procedures, is there in our sanctioning policy, so that we can deter educators from the schools in particular in terms of hiding the cases, because you would see many schools, because of the image, because of a lot of other issues, trying to hide those cases from SACE and also from the public. And I think it also covers Honorable Ngobeni in terms of mandatory reporting. And I'm trying to make sure that I deal with everything. Honorable Sheriff, you asked a question around issues of registration, re-registration, and also revisiting. I think it was Honorable Komani, revisiting the reissuing of certificates. Look, before we can issue any certificate, there's a process of vetting. From our own side, we vet from SAPS in terms of the criminal record database. We also vet from Department of Justice and Constitutional Development, because since 2019, we've been having a good relationship of working with them in terms of vetting, including recently the Department of Social Development in terms of accessing it to deal with whether that particular person is fit to work with children or not. And would have seen, I'm happy when DBE was presenting, also student teachers were beginning to deal with that particular process as well. So the issue of re-registration hasn't commenced. I need to put that on record. Currently, we're dealing with once-off registration. However, part of the processes that we've taken to the DBE for the process of amending the Act, it's an issue of how do we deal with vetting after 5 years and also re-registration process. It's also an issue that we are consulting the stakeholders, teacher unions, and everybody on, so that when we finalize the issue of the Act, those issues would have been dealt with from that particular perspective. So yeah, I was responding to the issue raised by Honorable Komani, but also issue raised by Honorable Sheriff. Again, Honorable Sheriff, you raised an issue of the slide that is speaking to 134. That is the cases that were concluded during the 2024-2025 financial year, but also that slide is showing you different sanctions, and it's also showing you some of the cases that were withdrawn and closed because of evidence. It was one of the reasons. But also sometimes a person will come and say, I'm no longer interested. We've settled the matter, and therefore the case must be removed. And also the issues around the parents and who would say my child cannot go and go for another disciplinary hearing because of the secondary trauma that has already been explained. So the ones that you see that have been closed revolves around that. But the other numbers are speaking to different sanctions that we have. And I think the issue of indefinitely has been explained already. I don't want to go back to that. It's very, very important. It's also in the Act. Section 5C is very clear that we struck off indefinitely for a particular types of cases. And therefore, that concept, we are using it within that particular context of the Act. The number of cases, Honorable Mkize, 612, and I know also Honorable Sheriff raised the same, more or less the same issue. We spoke about the 612 cases overall that we concluded. That number is coming from the cases that were reported during the financial year 2024-2025, but also some of the cases were coming from the backlog cases that we've already explained, and I think we explained thoroughly when we were presenting the annual report. So it's 612 out of 1,576, Honorable Mkize, and it's giving us 38.83% of the completion of the cases. The other area, Chair, there are a whole lot of issues that Honorable Shkwambani raised, and therefore we will look into them. Some of them were comments, some of them were giving some advice, and therefore those are welcomed. Chair, we will also look into them, and also how do we advocate to the public, how do we advocate to the parents and also to the learners. We are going to work on a campaign that we are finalizing through an MOU with your South African Human Rights Commission, so that we can deal with all these issues from that particular perspective and share resources and share processes of how to deal with that. And that would be a bigger campaign that would involve your learners, you to involve your parents and also the public as a whole, so that we can be in a position to educate even the parents, to educate everyone. When we were dealing with the Gender Commission, one of the recommendations that came up in terms of parents that are really refusing to have their children testifying for those reasons that are not valid, there was a proposal to say perhaps we need to report these cases to SAPS, but also to Department of Social Development, so that they can deal with them from a child protection perspective, and not just leave it. Like I know one of the honorable members indicated, I think it was Honorable Shikomban, to say, how do we even follow up in terms of those cases that have been reported to other institutions? And it's something that we need to take into account as we deal with our processes and refining them as we go. Chair, I think the issues that you were raising, it was more around the legislative gaps, and I think Dr. Foster dealt with them. I'm not going to repeat that. And Honorable Law, I know there are issues that you raised in terms of continuing professional development and support. In the presentation we showed under slide 22, 23, 24, that, remember, SACE doesn't have a direct responsibility to deal with continuing professional development. But from what we've endorsed, you will be able to see some of the programs that are there to deal specifically with Code of Professional Ethics, to deal with implications of Bella Act in terms of, in fact, your SASA is amended by Bella in terms of the redefinition of corporal punishment, because in terms of our cases, those cases are rising. The number of cases around that area are now going up because of that particular redefinition. But also, you correctly indicated, what are we doing with student teachers? We've developed a code of professional ethics for student teachers. Almost 19 higher education institutions have been visited. We've dealt with that quite a lot. And therefore, we are happy that at least from that particular perspective, we can say something is being done in as far as that particular area is concerned. The issues around gender equity, again, in the document, the presentation that we've sent, you would have seen that there's a program that we are running with women principals, women school management teams, so that we can begin to assist them in terms of their issues around gender inequality and how are they being prepared to really be in a position to participate meaningfully and be empowered to occupy those positions that are there within the schooling environment without any fear of patriarchy issues and a whole lot of other issues. There's a book that they've already written. You would have seen in one of the slides in the presentation in terms of that particular area. The other issues, Chair, I think they were covered from the from the responses that were given from the ELRC. Otherwise, I would be repeating some of the things that they've already indicated. I'm trying to check quickly if there's anything that honorable members want us to respond to, they can highlight, but I try to summarize as you requested. Thanks. Did I leave anything? Okay. Thanks, Chair.
Thank you very much, CO. I had a number of questions, and I see on the chats that members believe there are some questions that are not responded to. I am at this point going to request the team, and I'll submit also my written questions, because I had a number of questions, especially also to SACE, about the role, the responsibility for professional development of teachers. However, in the same breath, seems to say it is not necessarily directly your role to ensure that there is professional development of teachers. So there's quite a number of questions I have, which I believe I will agree, or I will propose that we submit written questions to both ELRC for the unanswered questions and also to SACE, just just to ensure that we are on time. And I want to then really thank yourself, the two councils, for taking time to meet with the committee for the presentation. It is really enhancing some of the questions and the gaps that Parliament is dealing with as it conducts the statutory rape inquiry. But we are learning, and I think we must accept that the problem is more complex. And because it is a complex, serious, complex societal ill, which of course is very gruesome. I mean, gender-based violence, it's really gruesome, and as it pertains to our children, it is something that we must do everything in our power to prevent. And if it does happen, we must do everything in our power to ensure that attaining justice is a seamless process. So there is a lot of problems because it is a complex issue, and we would need to really look comprehensively at the gaps. What are the gaps? With all the laws that are in place, with all the different councils that have been established, with all the regulations, with all the advocacy that has been done, that is being done by government, why are we still here? And I think that's very important on our part. So I'm going to thank the two councils, and thank you for your time, and the department as well. I know that the department did not get an opportunity to respond because, of course, this is also your conversation. Although the two councils are here, it's also your conversation. And as a result, there are some of the questions that were asked that really relates to the department. And I do also had some questions that related to the department, and we are going to submit those written questions to yourselves. Our rule here is that we give you 7 working days to respond to the written questions. So we'll do that, and thank you very much for joining us this morning. We are now going to release you so that we can deal with the rest of our agenda. We've got a plenary at 2 o'clock, and I am aware that some members still have to travel from the villages to the Good Hope chamber. As a result, we would really want to be done at least by 1 o'clock. We should be done. Thank you very much, and you are excused from the meeting. Mr. Brown, can we quickly deal with the outstanding reports, the outstanding items? This is, honorable members, we've got 2 reports that we want the committee to deal with in this meeting. The first one is the draft portfolio committee report on the oversight visit we undertook to the Free State. The report was sent to us for members to peruse so that we can really either enhance the report so that it reflects exactly what transpired, but also to adopt the report and so that we can submit it to the office of the speaker. Are there any hands that want to interact with this report? Honorable members, these are hands for corrections, for amendments on the report before we can get to the adoption of this report. Honorable Sharif.
Thank you very much, Chairperson. And I must say that Mr. Brown did a very good job on this report. It's exceptionally detailed. But Chair, there are some recommendations that we made that does not reflect on this report. I'm just quickly going there. Specifically, I think it was Lena King. We asked for a report on dropout rates for the past 3 years, if we could just include that. And then the meeting on Friday, the general overview of the when we had that meeting, we did ask for a report from the MEC's office in regards to the amount of students that have been progressed. I think that's the proper word to be used from grades 8 to 12. And then also the province and the district must send all written reports from the circuit manager around Veyveld Agriculture Secondary School. So if it's okay with Mr. Brown, I can just send this to him in a quick email and then he can just update it. But that's all from me, Chair. Thank you.
Okay, Mr. Brown, just let's just double check if we've not received those reports. I mean, especially the one on the dropout rate that speak to the specific school. But the recommendations, the overall recommendations on the Friday meeting, I think Honorable Sharif should share with you so that we can include them. Because the recommendations for specific schools, some were requests that we had made, which were going to enhance our discussions for Friday. So if we've received that report, for me, then there is no need for us to put it on the specific school recommendation, but to go back to the overall recommendations of the Friday meeting and say, have we not captured it there? Because those are the recommendations that we are going to expect the department to respond on. Any other addition? Okay, in the absence of any additions, honorable members, can we then move for the adoption of this report? Honorable Lowe.
Thank you very much, Chair. I wish to move for the adoption of the report with the amendments made. Thank you.
Honorable Sharif, are you seconding the adoption?
Indeed, Chair, I second the adoption with amendments. Thanks, Chair.
Okay. The report is duly adopted with amendments. Can we go to the next report? I believe it's the report on the G20. Honorable members, this is a draft report of the Portfolio Committee on Basic Education on the invitation to attend the G20 Education Working Group Seminar. This is a workshop which I could not attend myself due to flight issues. My flight was cancelled twice on 2 days. And I don't know, Mr. Brown, if we can get members, especially members that were able to make it to the seminar and that have represented us. This is mostly your report. Can you please assist us in this regard? I'm not saying it's your report, it's our report, all of us. But what we're saying is that the contents of what transpired and what happened and what was presented, it is mostly known by yourself. We've went through the report, so we've got some form of an appreciation of what exactly happened during the working group seminar. Honorable members, any additions, any amendments on the report? Okay, no amendments. Can I see a hand that seeks to move for the adoption of this report?
Chair,
Seemingly,
I
only
wish
member
to.
that represented us is Honorable Mkhize for this.
Yes, yes.
Yes.
So I would want to adopt. If can you please browse up, Honorable Mr. Brown, just browse up. I want to adopt immediately.
You want to move for the adoption?
Yeah, but just if you can just browse up.
What are you looking for, Honorable Mkhize?
I'm about to finish, Chair. I'll tell you now. Yeah, adopted, Chair.
Okay. Honorable Mkhize moves for the adoption of the report. Honorable members, any seconder?
I don't know whether can I second, Chair. If yes, I'm
Yes.
seconding the Honorable Mkhize.
Yes, you can second, Mama Kaba. It is our report. Mr. Brown, can we then go to the first set of minutes?
Chairperson, there is the one report on Milnerton, which we also shared with members
Oh, yes,
some time back.
yes. Oh, yes, Mr. Brown, that's correct. Honorable members, as per the discussion of the committee, I think we had a telephonic discussion, and we agreed to conduct an urgent oversight visit to Milnerton High School after the incident that took place, and we did undertake that visit. That is the report. I went through the report, honorable members. I am checking with members if there are any amendments, any corrections that members are proposing to be made to the report. Okay. In the absence of amendments and
ga ke re ke a mo ke a timela mo ke palla ko go emisha letsogo wa ntumela.
yes, Honorable Coman.
Yeah, ga ke go leboga Kgaldi, thank you very much for bringing this to our attention. Ke no ba ke rata go raise something sa gore with this report it can be proper for us to engage it up to infinitive, whereby we'll be having the a resolution of that matter. Must not just adopt it and then leave it like the way it is. As far as we know, or what have you found on our oversight? There were a lot of lies on the table, which means we must do follow-ups. Then so that's was about to just to raise to special treat the report the report of this oversight of Milnerton. Thank you very much.
Thank you, Honorable Komani. I think, honorable members, so this is a report on what transpired when we visited, because we need to be able to account to Parliament on what happened when we visited. So we can take a special resolution after we adopt the report on how we should move forward. And Honorable Komani, your concerns are, I do have the same concerns, because when we left, we did request that certain documents are sent to us. For example, the Form 22 that we since received, and when I went through that Form 22, I realized that actually when we were at the school, we were told that the school reported, I think it was on a Wednesday, but the form actually indicated otherwise, that the school reported the matter, officially filled that Form 22, not immediately after the matter was reported to them. They actually filled that Form for 22 about 4 days or 3 days after the matter was reported to them. And those are some of the things that also, as you look through the additional information that we had requested that you receive. And also that we've not received a report on the first case that took place, the first place that the principal acknowledged that they did have a case. We requested for a report on that case. I have not seen it, unless if I would have, it would have been on my part if it has been sent. But also we know that the disciplinary hearing was held, and we were promised that we will be given a report on the outcomes of that disciplinary case hearing, but we have not received that disciplinary hearing. So I do believe that there is a need for that follow-up meeting, which we did speak to the department that we will at some stage see if we cannot have a follow-up meeting, even if it's not in the premises of the school. But one must also mention that the incidences of bullying are seriously on the rise, and other provinces are involved. I mean, Honorable Sharif did request that we make a turn to Gauteng, where a very unfortunate, very gruesome incident took place, and we couldn't, in terms of what was feasible, who was available to attend, and the funds of the committee and the request, we couldn't. But I do believe that we can make a recommendation on how we approach it. I do believe that we need a follow-up session with the school on the outcomes. But because we were told that after the disciplinary hearing, the committee still has to submit their findings to the district, and the district to the PED, and the PED then takes a final decision. We said to ourselves, we'll give them a bit of time to do that. Even if it's a 7-day period, we'll give them that time to actually go through those processes, and then we can see when we then call back the school. However, we need to then take a decision on how do we deal with the other issues that are coming out of all the provinces, everywhere else, these new emerging cases. Honorable Sharif?
Thank you so much, Chair. I just wanted to pick up on what you said and agree with you completely that this is a South African issue. And I think as part of our recommendations, with that meeting where we summon the PEDs on their APPs, that they must also come and give us a report on their anti-bullying efforts and interventions, because only dealing with one province will be short-sighted on our side when we have, sometimes we only find out about things when they make news, but that doesn't mean that it doesn't happen. And so I just want to support you in your recommendation around calling the PEDs to come and report to us, because like you said, we might not have the resources to be able to travel across the country when specific incidences happen. So I think we also need a closed meeting as the committee to discuss on the terms of reference on how we actually deal with these things. Because if we are going to be picking up and going when there's a media story, we're going to be leaving some places out, like we've unfortunately left Gauteng out now. But what we can do is summon them, even if it's a virtual meeting, and deal with it from that perspective, from a top perspective, and not necessarily just going to schools when things happen. Thank you, Chair.
Okay, that's noted, members. I think I agree with that approach, Mr. Brown. We already have scheduled meetings with the PEDs the other week. The first set of PEDs that are coming, we should make an addition of bullying. If they've got their anti-bullying, we want a report on how they are effectively dealing with bullying in schools. And they should bring us stats of the bullying incidences that have been reported and how they've been dealt with, and the number of schools that have comprehensive anti-bullying policies. So that should be part of the reports that the departments bring. But as it relates to this report, Honorable Komani, I fully agree with you. We will have an engagement as the team to see when we can then slot in the PED and the school to have that follow-up meeting that we said, if needs be, we will have. Can we then adopt the report, honorable members?
Honorable Chair. Honorable Chair.
Yes, Honorable Kaba.
My name is Bridget Klabanchaba. I move to adopt the report to be adopted. Thank you, Chair.
Thank you, Honorable Kaba. The Honorable Kaba moves for the report to be adopted. Any seconders?
Report adopted, seconded. Adoption seconded, Chair.
Okay, Honorable Mkhize seconds the move for the adoption. Okay, Mr. Brown, now it's minutes. Okay, honorable members, this is the set of minutes of the meeting held on Tuesday, the 28th of October, and this was a meeting on the consideration and adoption of a committee draft budget review and recommendation. So this is a meeting which we held last week to go through the BRRR report so that we can adopt it as a committee. So, honorable members, any amendments, corrections? Any hand that seeks to amend, make corrections on these minutes?
Chair, without raising hands, sorry. One thing that I couldn't find, there was a point raised and I received by the minister during the meeting to create a hotline for unregistered schools so that we can protect our young people from vulnerabilities happening. I'm not sure how we should put it here. She has to say the minister has agreed to assist with putting what called the hotline in place. She actually said she will be able to do that, so that we can start with the process of making sure that people know what number to call if they suspect, and there's someone who will quickly check for them if the school is registered. If not, we take the police there and we arrest the criminals.
Yeah, honorable members, so this the report should have a comprehensive recommendations by ourselves. The report itself, Honorable Mkhize. I will tell you why the report itself is important that is in the report. Is because if it is in the report itself, then we are able to monitor, as you're saying, because we must monitor the recommendations or the implementation of the recommendations made in the BRRR report. But the other issue was that my recollection is that the department said they will consider. And if I think that's how we can put it in the minutes, but what I heard was that they will consider the recommendation or the proposal on the hotline. And that's exactly what I heard, unless if other members heard it differently.
I will not oppose you, Chair, on this one, but if you could go to the video, you will see the minister say we will be able to support that.
Okay. So I think, Mr. Brown, let's just check the recording on the exact words used by the minister, because we when we do hold the department accountable, it ought to be on something they committed, and we are able to prove or account ourselves that the department did commit on this matter. So let's check the recording, Mr. Brown, and get to a point where we understand what was the accurate framing of this commitment. Any other amendments? Honorable Sharif.
Chair, I move to adopt the minutes as a true reflection of the meeting.
Honorable Sharif moves to adopt. Any seconder?
Chair, Honorable Clever here, I second the adoption. Thank you.
Okay, thank you very much, Honorable Kaba. That was the last set of minutes, honorable members. Mr. Brown, that was the last set of minutes, right?
That's correct, Chairperson. Thank you.
Okay, thank you very much, honorable members, for your time. Please do forward those questions that are not responded to, that were not responded to by the two councils, so that we can ensure that we send that to both councils for them to respond to the committee. I'll also send the list of my questions, Mr. Brown, and then you can then ensure that everything is collaborated and it's sent to the councils. Thank you very much for your time, honorable members.
Chair,
Please
Chair, before you
remember.
close,
Okay.
Chair, let me apologize. When I was trying to nominate Honorable Whip, Honorable Law, I was on the during the medicine that I was drinking. That medicine it make me to be drowsing. So yeah, because I'm still in the treatment of doctors. So I apologize the way I was saying.
Okay.
Yeah, remember I said interim instead of saying acting.
Okay.
Yeah.
Thank you very much, Honorable Kaba. Of course, we wish you speedy recovery, ma. We are aware that our last meeting you had to leave and you had to be assisted and attended to. We really wish you a speedy recovery, ma, and we hope that you get better very soon. And we appreciate your commitment to the committee. Even when you're not well, you still try to log in and keep up and participate, and that is really commendable. So thank you very much, Ma'am Kaba, and the apology is accepted. Thank you very much, honorable members, for your time. The meeting is just a brief update that next week we are dealing with the present. We are dealing with it's a 12th. Nurse is posh. It's the 12th.
11.
It's 11th. 11th. It's posh.
It's 11th. It's 11th.
So, but that is our date for the inquiry. When is our inquiry?
Chairperson, yes, the meeting next week is the committee's engagement on the statutory rape inquiry. That'll happen on Tuesday, the 11th.
Okay.
And that meeting, we
Yes, I
have
wanted to
permission
give that update. Yes, I wanted to give that update to members so that they are on the same page with us, Mr. Brown, that members, you would have seen that in terms of our program, we had to move our meeting that was supposed to be held on Tuesday with 3 PEDs. We had to move that meeting to Friday so that we can accommodate the inquiry as per the dates that were articulated or outlined by the leading committee. So the leading committee had initially said that we must lead our engagements on the 12th. Now the 12th fell on the Wednesday, and we know that some of our members are also members of the higher education and other committees, and as a result, Wednesdays are quite tricky for some of our members. So we just really swapped. We shifted our standing meeting or standing engagements with PEDs, 3 PEDs to Friday. And we're going to have that engagement virtually with the 3 PEDs, but we're still going to have that discussion with Mr. Brown. Then we're having our session, our engagements on the statutory rape on Tuesday. Sis Posh, can you please just flight the proposed program?
Good afternoon, Chair. Good afternoon, honorable members. Mr. Brown, do you mind to please flight the program? Thank you.
She's Porsche, is that the program you sent me last? I think you sent me yesterday. I'll find it quickly.
Yes,
Thank you.
please find Mr. Brown. Just an update for members to understand how we are going to how we're going to approach this engagement and this inquiry. Says Posh, just a very brief update. I want us to conclude this meeting so that members can make their way to plenary. Just a brief update on the stakeholders we've invited, the progress update that we've already invited stakeholders and those stakeholders we've invited, and the program on the role of members in the program itself.
Thank you, Honorable Chair. Mr. Brown, send the letter that you sent me yesterday. We will take the members through. Thank you. Honorable members, thank you very much for the guidance of our chairperson. Thank you, Chair, for your time that you met with us last week as the Secretariat. We truly appreciate, Chairperson, your guidance when you sat with us and allowed us to also put some questions as to the approach of the process that the committee will engage on. Honorable members, this is just a draft program. Draft because we're to also liaise with the chairperson as well and also look into the phase approach of the statutory rape as it is also progressing in other provinces. And thank you to our colleagues and the members who've attended previous ones. As it stands, honorable members, it's a draft subject to still correction and also the names of the presenters that will present. As a first draft, honorable members, the first column is time, then the activity, the stakeholder or presenters. Our Honorable Chairperson, Honorable Maimela and Honorable Low will be co-chairing the first session, whereby honorable members, in terms of the time, by 9 o'clock, everybody must be at the venue, which is identified. The identified venue, as per the discussions we've had, was a hybrid venue, which would accommodate both the physical or virtual, but most importantly, the department has to be present physically, as well as SACE being present physically and members to engage. I think Mr. Brown will also update the committee in terms of the availability of a venue in Parliament or outside, which may accommodate the hybrid format. We will start with a registration desk in terms of the number of people who will come through, those who have made themselves available. And then at the opening and welcome, our Honorable Chairperson, Honorable Maimela, will take cue of that first session in terms of the welcome and introduction of the participants. And then the objectives, I will put in an input there. Then allowing the department to do, as per the minister, normally do some overview of the department and how they are looking into this matter. The deputy minister or the DG taking care of the department's presentation, and then followed by SACE, that is Ms. Mukhalane. Also the other stakeholders that have been invited, which is SATU, NAPTOSA, or any other trade union that has confirmed to come through. The presentation by the Council of Learners. We also have identified, Honorable Chairperson, as per the guidance, the issue of the SGPs and other organizations like the Child Legal Centers, the Equal Law Foundation, etc. But at the point of drafting, we were trying to get those names through. The names that you see here, honorable members, are not just these names, but other names. With Mr. Brown, after this meeting, we're going to sit and augment them. After lunch, honorable members, we felt there would be a session whereby the members themselves will also lead the questions or the sessions. For example, session 1, the questions that are in the ATC itself, that are in the updated program of the statutory rape, that some of the members may lead, like, for example, Honorable Sharif and Honorable Shikwambana leading or co-chairing the after lunch session, followed by Honorable Kabanjaba, Honorable Ngadi, Honorable Mkiza, and the fourth one, Honorable Van der Walt. Any member that would be available, or maybe say, I'm not available, maybe look at this one. We were just making examples at this particular point. And what will be important, honorable members, is that there are recommendations that we want to note at the end of the sessions. But before that, also, we take note of the submissions that would have been received from the public. Now, that point of the submissions is the organizations that also want to present at this specific inquiry session, and those Mr. Brown will put up into this program so that as the program is amended and made finalized, their names will be reflecting here. Now, once they have, once their submissions are also received, we note the issues which emanate from the submissions. What are the legislative gaps? What is coming up in terms of the data and the statistics, and the way forward that members and the public would be actually highlighting. Then the chairperson will do some reflection as well as the closure and then another member doing the vote of thanks. Honorable members, in the drafting of this program, we felt it will not necessarily be an ordinary meeting, but a meeting where stakeholders are engaged by the committee itself towards another phase where what we have done as a portfolio committee on basic education, inputs emanating out of this session will report directly also to the other processes which are taking place. For example, the other committee on police, the other committee on social development. I think social development, Chair, if I'm correct, will also be coming through for our specific meeting. And then one consolidated report will be done. As the meeting is also ongoing, by this afternoon, we will try as the Secretariat, honorable members, to draft an implementation plan which starts to highlight when we say we're working collaboratively, in as much as this is a portfolio committee's work, but there's some parts of collaborations that we need in terms of resources as well to make sure that this process is seamless and that the desired outcomes of what is wanted from this statutory rape inquiry meets with the ATC of Parliament. That's where I could stop, Honorable Chairperson. I thank you for now, just as a draft program. Am I still audible? I think I'm done, Mr. Brown, for now. Honorable Chair, I can give over to you.
Thank you very much, Ms. Posh, for that update. Honorable members, that was just an update on how we are going to approach the engagement next week. So that honorable members are not shocked. The second session, we wanted honorable members to also participate. So you will be facilitating responses to specific questions that we must respond to in this inquiry. Remember, we are just one segment of the entire inquiry. So from the basic education context, we ought to respond to certain questions. And we are going to allow honorable members to facilitate the response to that question by the participants. So it's not us. This is one session where we shouldn't be listening to ourselves. Even the presentations by the department, says Posh, we must really shorten it. And we can't have an overview by the minister in our program, in our own engagement. This is our program. So it can't be an overview. They can't give an overview. What they should do is to give a presentation like all other stakeholders who are coming to bring a presentation before us. So in this session, we are going to do the more listening and less talking so that we're able to get a sense from all the stakeholders on where are the gaps. And that is why we want members to facilitate the responses to that question. And also on the program, let's just correct that we really give the department SACE because we speak to them all the time. We speak to each other all the time. We've been engaging with each other all the time on these issues. So we must give them really just a brief chance to give a presentation on whatever they are doing. And we did also, says Posh, invite the PEDs. We should ensure that we also write a follow-up letter to the PEDs to say it is very important that they participate in this inquiry. I thought we should just brief you, honorable members. If there is no any other question, we are going to close our meeting here today. And if members have any other questions, clarity-seeking questions, you feel free to engage with both Honorable, Ms. Posh and Mr. Brown. Between the two, they should be able to give responses to any clarity-seeking questions. Honorable members, the meeting is adjourned, and thank you very much for your time.
Good morning,
Thanks, everybody.
Thank you
Goodbye.
very much, Chair.
Thank you, Chair. Bye.
Thank you,
Bye.
Chair. Bye.
Mr. Brown?
Mrs. Posh.
Yeah, can you speak offline by 1:15?
I've got something I need to do right now. I'm going to be back from that engagement by 3:00. I've got to move now. In fact, I was hoping I would be done by now, but let me call you offline quickly and then we can have a quick chat.